Welcome to the first day of our spring oral argument session here in Pittsburgh. I know it doesn't feel like spring, but this is spring in Pittsburgh. As you may know, the Pennsylvania Supreme Court is the oldest appellate court in North America. Our roots date back to William Penn's Provincial Court of 1684, and our Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722. In 2022, we celebrated the historic occasion of our 300th anniversary in Philadelphia, and we, members of the court, are very proud of our rich history. We sit today in Pittsburgh's City County Building, a 1917 granite Art Deco building, which was designed by renowned local architect Henry Hornbostel. The City County Building houses executive, legislative, and judicial offices for both the City of Pittsburgh and Allegheny County. Architect Edward B. Lee was responsible for the design of this magnificent courtroom. The wooden oblongs, the fluted columns, and the bench and bar are all made of mahogany. Behind the bench is a beautiful mural of the state's coat of arms. That same coat of arms is carved into the justices' chairs, and individual elements are represented in wood medallions on the bench, specifically a ship carrying the state's commerce to the world, a plow working our rich natural resources, 3 golden sheaves of wheat representing our state's fertile fields, and our citizens' wealth of human thought and action. Finally, an American bald eagle demonstrating Pennsylvania's loyalty to the United States. The murals in this room were all painted by local artist Edward Trumbull. On the ceiling, you will see 3 great lawgivers, all framed by gilded plaster. Furthest from the bench is the Byzantine Emperor Justinian, famed for the Reformation and codification of Roman law. In the center is Moses, seated and holding the 10 Commandments. And finally, closest to the bench is the English King, Edward I, who spent much of his reign reforming the common law. To the left of the bench, to your left, you will see a mural depicting William Penn, founder of Pennsylvania, and to the right, William Pitt, the first Earl of Chatham, who was held in high esteem by the American colonists after publicly supporting many of their positions. The city of Pittsburgh is the namesake of William Pitt. It's truly an honor to sit and work in 3 beautiful courtrooms in Philadelphia, Harrisburg, and Pittsburgh. Before we hear the first case, I would like to remind counsel of a few things. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of your case. You may then begin by stating your name and the party you represent, and please introduce your co-counsel, if any, who are with you today. The justices are familiar with all of your cases, so I ask that you avoid any unnecessary recitation of facts or procedural history, and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for particular issues. Please remember that we do not allow rebuttal. In cases where there are multiple parties represented by separate counsel, you should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices when they are asking a question, although, admittedly, we may be interrupting you. A justice's question is not meant to trip you up. Rather, it indicates there are particular issues that we wish to explore further. While there's no set time limit for argument, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, please call the first case.
John Brown versus George Gaydos. Representing Mr. Gaydos, Mr. Glenn Cheesenoff. Representing Mr. Brown, Mr. David Halleck.
Good morning.
Good morning, Your Honor.
In this discretionary appeal, John Brown was injured in the course of his employment while attempting to operate a skid loader which had been left at a job site by his employer, George Gaydos. Notably, Gaydos owned the skid loader and initially purchased it to use in connection with a separate sole proprietorship that he owned. After receiving workers' compensation benefits, Brown filed a lawsuit against Gaydos, alleging that Gaydos was negligent by improperly maintaining the skid loader and failing to supervise or train Brown on how to use it. The trial court granted summary judgment to Gaydos, concluding that he was immune from suit under the co-employee immunity provision set forth in Section 72 of the Workers' Compensation Act. We granted allowance of appeal to determine whether, in order for co-employee immunity to apply under Section 72, the act or omission giving rise to the litigation must occur in the course of the employee's duties for the employer. Please proceed.
Thank you, Your Honor. May it please the Court, Glenn Shikhanov on behalf of George Gaydos and Gaydos Construction. Your Honors, 49 out of the 50 states in the United States require workers' compensation benefits, with Texas being the lone holdout. And each and every one of those states has co-employee immunity statutes that were enacted in order to satisfy the quid pro quo of the workers' compensation scheme. At the time the legislatures of each of those states were enacting these immunity statutes, they had a choice. They could enact narrow protection for co-employees by requiring that co-employees show both course and scope of employment in order to be granted protection. And states such as Washington and California did just that. Then there was a middle ground, and Kansas and Idaho employed that middle ground. They enacted statutes that required that co-employees showed that they were within their course of employment, but not necessarily within their scope. Yet other jurisdictions provided broad protections to co-employees, granting immunity to all employees in all situations when the injury to the claimant was compensable for workers' compensation benefits, without regard for course and scope. That was Ohio, Wisconsin, and Pennsylvania. Now, Your Honors, the co-employee immunity statute is codified at Section 72 of the Workers' Compensation Act. And the beauty for purposes of this appeal is that my esteemed colleague here and I actually agree it's an unambiguous statute. At least we agree in briefing. We'll see what he says during his time up. Your Honors, the statute is a single sentence. It has been interpreted by this court in Aplt versus Reichert to provide broad protection to, quote, all employees in all situations, provided only, that's this court's words, provided only that the injury was compensable under workers' compensation benefits. The Superior Court in this case erred when it held, they interpreted all employees in all situations to really mean some employees in some situations. And in doing so, the Superior Court added a phantom condition to Section 72 that simply doesn't exist within the statute. They required that the co-employee show that they were acting within their course and scope of employment as well. But the course and scope of employment element in Section 72 simply doesn't exist. And in Aplt, this court rejected that very argument. In fact, the appellant brought this exact same argument before this court, and this court said, had the legislature intended to require course and scope for purposes of co-employee immunity, it would have said that. But it didn't. And therefore, this court said it refuses to speculate or otherwise supplement that requirement within Section 72. Now, Your Honors, this idea that course and scope is required for purposes of immunity simply doesn't exist in the statute, and the appellee suggests that this analysis in Aplt is dicta. And I ask, how could that be? In Aplt, the first argument before this court, the first issue that the plaintiff brought was that course and scope must be required. That was an actual issue before this court, and had it gone the other way, had the court actually deemed it to be required, the Aplt could have gone the other way. The plaintiff perhaps would have won that case. But instead, this court said, we're not putting that requirement into the statute because the legislature didn't choose to do so. The concept of dicta is judicial commentary that's irrelevant or otherwise unnecessary to the issue before the court.
Counsel, let me ask you a question, and put aside the fact your plain language argument. What policy would the General Assembly have been promoting with the breadth of the immunity for someone who is in the same employ?
So, Your Honor, it's actually the policy behind workers' compensation benefits as a whole. When workers' compensation benefits were enacted, they were provided alongside both employer immunity and co-employee immunity. And the idea was that it's a quid pro quo. The quid is that you get immediate medical benefits and immediate wage loss, future earnings, etc., regardless of who's at fault. But the quo is that you give up your right to sue employers and co-employees.
Why? I mean, let me just use an example, and I'm going to use Justice Todd and myself as the example. I'm driving to Harrisburg for an argument session.
This is very realistic.
It is. Wait till you hear the rest of it. And I'm driving on the Pennsylvania Turnpike, headed to Harrisburg. Deborah Todd, my colleague and co-employee, for the purposes of my example, is driving in the opposite direction, coming from a spa vacation. And, she stopped along the way to shop, and, she's headed back to Pittsburgh, and she's driving, and she crosses the center line and strikes my vehicle while I am in the course and scope of my employment, headed to Harrisburg for an argument session. She would be immune under your example, correct?
It's not so much that it's under my example,
Well,
Your Honor.
I'm just asking, is that correct?
She would be.
Now, what does that promote? That's what my question is.
So-
And again, I'm ignoring for the purpose of my question that you have a solid, plain language argument.
Yes, Your Honor. If we were to take the Statutory Construction Act and simply cast it aside and only focus on policy, the promotion is really the harmony within the employer context. When workers' compensation benefits were enacted, Your Honors, these immunities were passed together for both employer and employee. And in the early...
But it was to benefit the employee so that they would always have coverage for injuries, correct?
Well, it was to promote the harmony with...
Not to protect the employee from circumstances involving their co-employees that have nothing to do with being in the employ of an employer.
Well, Your Honor, the purpose was to provide broad immunity, and the policy reason behind workers' compensation was this idea that course and scope on behalf of the defendant, whether it's the employer or the employee, doesn't matter. We only focus on the course and scope of the actual claimant. In the early 70s, claimants sought to challenge employer immunity by claiming this idea of dual capacity. What they said is if the employer, for purposes of the employer immunity, was acting outside of their course and scope as an employer, then they should be able to be sued, and they wouldn't be immunized. But by the mid-'80s, this court rejected that flatly. That's Lewis versus School District of Philadelphia and Heath versus Church's Fried Chicken. In both of those cases, and those are mid-'80s cases by this court, the court flatly rejected the dual capacity doctrine and explained that the sole focus for purposes of employer immunity has to be on the claimant and the claimant only. Whether the employer is acting within their course and scope as an employer or otherwise shouldn't matter. So I ask, how would it be any different for co-employee immunity? They were all passed, both employer and co-employee immunity were passed as part of a broader package for purposes of workers' compensation benefits and the protections you give up in exchange for those early benefits. So if the legislature, for purposes of employer immunity, and as this court already determined,
What is the employee getting in exchange for, what am I getting in exchange for not being able to sue Chief Justice Todd, who crossed the center line and struck my vehicle? I mean, if it had been anyone else in the audience, except people who also, work for the court, I'd have a claim against, a direct claim against that tortfeasor.
that's correct, Your Honor. That's actually Gardner versus Erie, where this court explained that you have claims against other people, just not co-employees.
Obviously.
Absolutely, Your Honor. But what you're...
Like the remedies clause would assure that, circumstance.
What Your Honor is getting is the immediate medical and wage loss and benefits. And it seems to me like Your Honor is speaking to the fairness concept of it all, which is what Aplt spends effectively half their brief on. So for purposes of, if we were, again, to ignore the Statutory Construction Act and simply speak on policy, this idea of is it fair to get immunity under the exact scenario that you're...
I'm not talking about fairness. I'm just talking about a rationale. I mean, this doesn't advance the cause of reducing costs on the part of employer. The employer Justice Todd's employer would not be on the hook for my lawsuit against Justice Todd. And honestly, this notion of promoting harmony, I'd still be angry at Justice Todd for crossing the center line and striking my vehicle. So
I would not be angry because apparently I just had a relaxing spa weekend.
that's right. And you walked away uninjured, so in my hypothetical. But
Well, Your Honor, the promotion really is that the policy is focused specifically on the claimant, and that's where we get the dual immunities between employer and employee. If workers' compensation benefits solely focus on the claimant's actions and not on the employer's actions in the employer immunity context, I don't know how the legislature could ever make a 180 and all of a sudden focus all of their analysis on the co-employee course and scope of employment when it comes to the co-employee immunity. It wouldn't make any sense. Those two immunities were passed together for a reason.
since about 1980, in my hypothetical, the injured employee, myself, would get work loss and medical benefits through the, motor vehicle financial responsibility law. So,
Your Honor would get the workers' comp benefits as well, and then your workers' compensation carrier would very likely have a lien against any other automobile policy you have.
that's why my motor vehicle accident case wasn't the best, because of the subrogation issues with motor vehicles.
That's correct, Your Honor.
Yeah.
What I would like to note on this point, Your Honor, specifically for purposes of policy and employer immunity, is that Appellee's brief refuses to address this issue. We spent an entire subsection briefing it, and Appellee at footnote 3 simply says, this is an attempt to distract and been rejected by prior courts. That's patently false. No prior court has ever considered this, because a secondary issue at the lower level that's not before this court today was simply whether Mr. Gaydos was or was not an employer to begin with. Certainly if he was not an employer, employer immunity would never trigger, with or without dual capacity. But this idea that it's a distracting element and its refusal to address it is telling, because that's specifically part of what workers' compensation was passed to do. These immunities were passed together. They were considered by the legislature together. I don't know how they can have a completely different consideration for
They're worded differently.
They are worded differently.
So when the General Assembly uses different words, you try to give it different meaning. So I'd like to move away from policy and go back to the statutory language, which you seem to think is clear and unambiguous. The immunity language that we're looking at focuses on, I would say, not on the employer, not on the employee, but on an act or omission. It focuses on any act or omission that occurs while the person who you want to sue was in the same employ.
That's entirely correct, Your Honor.
So I understand course and scope of employment. I've seen it in numerous different concepts. I'm not sure why it's being injected here, other than the fact the simple question is, did the alleged act or omission of Mr. Gaydos occur while he was in the same employ as the injured worker? That's the only question.
That's precisely correct, Your Honor.
So the alleged actor, there are a couple of alleged act or omissions here, but I want to focus on the one that I think is the more complicated question. Mr. Gaydos, apparently factually, there's no dispute. Is it his brother he was in business with? Is that?
He's a
cousin?
cousin.
Went to a great deal of intentional effort to separate the ownership of this loader from the joint venture he's in with his cousin, correct?
He actually tried to form an LLC, Your Honor. It just never came to fruition.
But he clearly wanted to keep control over this loader. He didn't want to hand it over to the business.
It was owned in his personal capacity. That's correct.
Right. So he was effectively, if he didn't loan it, they would effectively had to go out and hire a third party to deliver a loader that they could use for the project.
That's correct.
Okay. So I guess the question is, the allegation is you were focusing on act or omission. The allegation is that Mr. Gaydos negligently maintained the loader. So the question is, statutorily, when Mr. Gaydos negligently maintained the loader, was he in the same employ as the injured worker?
That's precisely correct, Your Honor. And the way that the Aplt court read that in the same employ is co-employer. So co-employed by the same employer. So,
but again, at the time of the act or omission, were they in the same employ? And that's what I'm asking you. When he was maintaining the skid loader, who was he employed by?
Well, Your Honor, he was always a co-officer of the ACS. But the bigger issue with what Your Honor is proposing is that the actionable negligence actually occurred when he gave the skid loader for use at the job site.
No.
Simply owning the skid loader and
No, that's not what I said. The allegation, as I understand it, there's a couple of allegations. There's an allegation of failing to adequately train the injured worker in this case, which arguably would have happened on site, versus something that happened before the skid loader was delivered to the site in the capacity of loaning the equipment to the third party. And the question is, I focus on the act of omission because that's what the statute focuses on. When this act or omission, this alleged negligent maintenance happened, were they in the same employ?
And the statute is asking, at the time of the act or omission, what was the status of both of them? And the status where they were employed by ACS together.
Well, and this is where this argument collapses, right? Because I'll give you a different example. I'm not going to go into whether Justice Doherty and I were at a spa together or anything like that.
Probably were.
I'm going to get into, these are construction jobs. So let's say somebody works part-time construction, but on one day they were an Uber driver, and they were delivering Uber Eats to a job site. And they came in hot, hit a scaffolding on the job site, injured worker falls from the scaffolding and gets injured. Just so happens the driver of Uber Eats works there part-time, is an employee. Under your reading of act or omission and being in the same employ, that Uber Eats driver would be immune.
It's not so much that it's my reading of it, Your Honor. It's
Well, today it's your reading.
Yes, Your Honor.
Yes.
That would be my reading based on the Statutory Construction Act, Your Honor. So as Your Honor is,
I don't think that's what Apple says, but I'll go back and read it again.
well, Your Honor, I can clarify what Apple says. So
Because Apple involved two people that were driving.
they were driving together, but the court said that wasn't relevant. What the court instead said is,
There was no issue in Apple about were you working for somebody else at the time versus working for somebody else at the time. That was not the issue.
No, they were both
There was
employed.
no multiple employer possibility in Apple.
yes, they were both employed by the same employer, and for that very reason, immunity was granted.
But here you have a multiple employer issue.
But that's the point, Your Honors. If they're both working for ACS, and the question presented that this court accepted for review was if it is presumed that they are in fact working for the same employer, which makes them co-employees, co-workers in the same employee
At the time of the act or omission.
at the time of the act or omission, yes.
What does that mean then? Why didn't it just say if you're why does it even focus on act or omission? Why is that language even in there if it's just all co-employees under all circumstances, if you get workers' comp, all co-employees doesn't matter. They're just completely immune.
Well, Your Honor, they needed to create a temporal limit specifically for the act or omission in order to make sure that it wasn't overly broad to provide immunity to co-employees that weren't actually co-employees at the time of the act or omission. So in other words, the statute says a person, any person, as long as the act or omission occurs at the same time as they are co-employees. Now, let's say Your Honor and I have no relation whatsoever. I hit you with my car.
I get you though at the same time. I get that. That's the problem though, is you're saying at the same time means were they, it doesn't mean they were necessarily as co-employees at the same time. It means were they on a spreadsheet somewhere under a list of employees that may or not have been working that day, being paid that day. I'm not asking about course and scope because you can be being paid outside of your course and scope. I'm saying you're just saying as long as they're on a spreadsheet that they are on the roster of employees, they get immunity.
That is all what the statute says, Your Honor. And let's take an example of two co-employees that work at a store, and they happen to leave clock out at 5 o'clock. They don't cease being co-employees, co-workers in the same employment. They maintain that status throughout, as long as they are in fact working for the same employer. So, Your Honor, this idea of...
So if that employee comes back and robs the store, they're immune from civil liability if they pistol whip their coworker.
That would be an intentional act, Your Honor. That's an exception under Section 72. So you actually wouldn't gain immunity.
What if they accidentally pistol whip them?
I'm pretty sure there would be some inferred intent from the robbery.
What if they tripped and caused a pistol whipping?
I think that there would be some inferred intent from the robbery itself, Your Honor, for a criminal act. But, Your Honor, I'm glad you brought this point up because I'd like to touch on the Statutory Construction Act. And I know since your days on the Commonwealth Court and throughout your tenure in this court, Your Honor has consistently preached strict adherence to the
Lives
statutory.
in the statute. That's
Statutory interpretation. I know who I'm talking to. So, Your Honors,
To a lot of people up here, though.
Your Honor, under the Statutory Construction Act, the first step to any statutory interpretation analysis is to simply ask ourselves whether the statute is or is not ambiguous. If it is not ambiguous, there is no second step. We don't reach all these policy considerations. We don't reach all these hypotheticals. They simply don't exist. Now, the Apple Court reviewed ambiguity within the statute and said it is clearly worded, clearly stated, clearly phrased, simple test. Those are all direct quotes from the Apple Court. I don't know how to take all those and say, but it's actually ambiguous.
Well, the facts in Apple were not, the facts in this case are different from Apple, and that's why we're here. Is Apple, there was no issue of this second employer.
But in Apple, what the verbiage of Apple is the analysis of the actual statute and whether the statute is or isn't clearly stated. We must remember, Your Honor, that in Apple, the claimant actually did try to challenge course and scope. That was his first issue. The court said, I don't want to hear it because it's not in the statute. So for purposes...
I agree course and scope is, that's what I'm talking, I'm not talking about course and scope. I'm just talking, I'm focusing on act or omission while in the same employee. I agree with you 100%. I don't think course and scope is a relevant consideration. I think whether an act or omission occurred while in the same employ. You can be in the same employ at the time of an act or omission and be outside your course and scope, but you're still in the same employ.
Your coworker, Your Honor, absolutely.
Right. So you know, I'm with you. I just think you're not facing the fact that the Apple court did make some broad statements, but in the context of a case where there was no question that they were both employed by the same employer at the time. Here, there's an allegation and a claim and a factual circumstance that is undisputed as to whether at the time of the act or omission that's at issue here, they were co-employees.
Your Honor, actually...
That's your argument about dicta in the Apple decision, right?
Yes, Your Honor.
I have a question for you regarding, you referenced the dual capacity doctrine. If we rule against you and accept the position that the lower court took, in your view, would we necessarily be revisiting or perhaps reversing some of those dual capacity cases?
We would effectively be abolishing them, Your Honor. And the reason is that the focus has to be on one or the other. Either the claimant is in the claimant's course and scope at the time of the accident, or the employee or the employer and their course and scope at the time of the accident. If in Heath and Lewis, this court said that the focus is solely on the claimant, and if the injury is compensable, that's it. That there's no more analysis. Immunity triggers. If we were to now abolish that in the co-employee context, the next step is to abolishing it in the co-employer context.
Well, is it the next step, or would we have to necessarily do that in this case?
Well, Your Honor, I would say that you would. And that's the problem here is that we have repeated precedent saying dual capacity doesn't apply. And again, Apelt refuses to address this in briefing for a reason, because this is a policy issue that needs to be considered. It just doesn't make sense that the legislature does a 180 on co-employee immunity versus employer immunity. They were passed together. So if we were to now revisit not just Apple, but also Lewis and Heath, we're abolishing a significant amount of precedent, Your Honor.
Counsel, can we get back to Justice Brobson's hypothetical? The plaintiff who's injured in his hypothetical, would he be precluded from suing the dual employer of the defendant who was a co-employee?
Yes, Your Honor, because the focus would be solely on the claimant and not on the employer.
I'm talking about, so that plaintiff is then precluded from suing the second employer of the negligent driver in this case.
As long as they were the employer, Your Honor, yes.
Yeah,
No, it's
because
not the employer.
it would be respondeat superior liability, and if the worker is immune, then the employer is immune.
Right, exactly, Your Honor. So, Your Honor, the real issue here is, I think we're discussing fairness when we're talking about this policy issue, and this is something that Apelt spends half their brief on. You know, and he comes up with these exaggerated hypotheticals, but in any statutory
Oh, we hate those.
It just happens, Your Honor. It happens in every brief, it seems like. But what I'd suggest, Your Honor, is it's beyond the Statutory Construction Act not allowing review of these hypotheticals. Even if we were to cast that aside, this idea of fairness really begs the question of fairness to whom? And what I mean by that is, if we were to explain the Workers' Compensation Act to a layperson, simply someone who is outside the law and doesn't understand how it works, we would have to tell them that a claimant who is responsible for an accident at a job site could nevertheless collect wage loss, medical benefits, and if they're significantly injured, or let's say paralyzed, potential future wage losses in a large lump sum. And the average layperson would look at that and say, but he's responsible for the accident. How could this be? But that is what the legislature chose, and that's their prerogative. That situation is no less unfair than some exaggerated hypothetical where, pursuant to this statutory language, a co-employee may or may not get immunity while outside of their course and scope. This idea of fairness doesn't reach this court because of the Statutory Construction Act. But if it does, we have to conclude that this idea of fairness is really in the eye of the beholder. And for purposes of statutory interpretation, the beholder is the legislature. That's what they chose to enact. That's what they chose to proceed with, and we have to respect that unless and until this statute is amended. Your Honors, the dissenting opinion at the Superior Court level labeled this as a simple case. Judge Stabile simply reviewed Section 72, applied Aplt, and said, well, they're co-employees.
Well, he's a very smart guy, so to him, to Judge Stabile, it was a simple question.
I very much agree. He is a very smart man. I think we should listen to him. But Your Honors, his reasoning is really something that's telling. He focuses on Aplt and says, I don't know how else to read this. It's an unambiguous statute that doesn't have any requirements outside of being co-employees. And we maintain that status throughout. Now, to the extent that the dissent goes further and explains that Aplt held this to be definitively true, that there's no course and scope of employment requirement, what the appellee suggests is we don't have to overturn Aplt, we can get around it. But there's really no way to do that.
Well, but Judge Stabile in his dissent focused on the time of the injury. He focused on the point, I think he said, was that the injury occurred while they were on the job site under the same employee of the same employer.
That's correct.
But the statute doesn't focus on the time of the injury. It focuses on the when the act or omission happened. So why, respectfully to Judge Stabile in the dissent, did the dissent just not read the statute by focusing on the time of the injury versus the time of the alleged negligence?
Well, Your Honor, the actionable negligence in this case occurred when the skid loader was brought to the job site. And what I mean by that is owning a defective skid loader at my home, in my garage, is not negligent. There's nothing wrong with owning a product that's, has a defect of some sort. But the second that I fail, or I bring it to the job site and let someone else use it, that's the actionable negligence that occurs.
Did he not request that it not be used until he got back?
He did, Your Honor. And
And the fact is, despite it not being part of the business, despite his claim not to use it, an individual used it. Does that not show an intentional act falling into your argument that intentional acts are excluded?
well, Your Honor, I would certainly, love the fact that there's a second argument to provide, immunity to my client. But the reality here is that he has allowed its use on prior occasions, and that is in the record. I have to concede that point. So it's something where this employee used it for purposes of the business that Mr. Gaydos did own a part of. So that's really not, it's not really an argument that we can go forward. It might be a liability defense now in the future, but it's not an immunity defense at this juncture. Now, Your Honors, the reality here is that Aplt is 54 years old. It has never been questioned. Since Aplt was passed in 1971, the legislature has not amended, revised, or made any alterations to the statute. And what that tells us under the doctrine of legislative acquiescence is Aplt got it right. When Aplt said that the legislature intended additional requirements, they would have put that in the statute. Now, Your Honor, Justice Wack, you've authored repeated opinions on this issue over the past, by my count, at least 6 years. And in those opinions, Your Honor continually states the importance of precedent and admonishes appellate courts for refusing to follow it. In those same opinions, Your Honor explained that precedent doesn't just age out. We don't get a redo every 10 years to just reconsider prior cases. Apple is a unanimous decision. It remains good law. And unlike Apelli, who tries to dance around it, I give credit to their amicus counsel. Their amicus counsel is just asking this court to overturn Apple outright. So at least I give them credit on that part.
But they can't do that. And I mean, to your point, I mean, I think we all agree that precedent just cannot be overturned, but we've not been asked to overturn Apple in this case.
That's correct, Your Honor. What the appellee is suggesting is there's a way to massage Apple into this, but I don't know how to review a holding that says all employees in all situations, provided only is the exact word used by this court. That creates a limitation. Provided only that workers' compensation benefits were paid. I also don't know how to read if the legislature intended course and scope, they would have said so. In fact, Your Honors, the Apple court astutely explained that there was actually a possibility that the legislature, in fact, intended there to only be immunity for on-premises accidents. But they refused to speculate on that. And that's the word the Apple court used. That might have been the intention. We don't know. But we have to take the legislature at their word. Because when a statute is unambiguous, we take them to mean what they say they mean. And so the Apple court correctly said, yes, that's a possibility, but we're not going to go that far. We're not going to speculate. We're simply going to apply the statutory language. At minimum, Apelli's position asked this court to overturn Apple without saying explicitly. At worst, what it asked this court is to amend the statute. That's up to the legislature. And frankly, Your Honors, to the extent that the appellee believes that this is an unfair statute and has unfair results, they need to go to the legislator. And they need to ask them to make that amendment. That's not what we're here for today. I believe the panel understands the issue well. Unless there are any other questions, Your Honors, I respectfully ask.
Questions, Justices? No, thank you very much. We'll hear from Mr. Houck.
Thank you, Your Honors.
Good morning, Chief Justice Todd, Justices of the Pennsylvania Supreme Court. May it please the court, my name is David Houck and I represent the appellee in this matter, John Brown. I think it's going to surprise my esteemed colleague, but I'm going to tell this court from the open, and it's consistent with our brief, we believe the statute is completely unambiguous. And in fact, we believe the statute should be read and applied in its entirety. And what you see from the Gaydos reading of this statute and what they have done from the very beginning from reading this statute is omit the qualifier that Justice Brobson has identified here at the very beginning of this discussion. And that is that did the act or omission that caused the injury occur while in the same employ? When Gaydos reads this statute, they completely skip that verbiage. They make it superfluous. And that allows you to get the absurd results that Justice Donoghue was bringing up here. The Gaydos reading of the statute creates unlimited liability, which is completely in opposite of what the Workers' Compensation Act is about. It is remedial legislation. It has humanitarian purpose, and certainly an interpretation that favors a person who causes a work injury over the injured worker when it happens in the scope and course of employment has to be disfavored.
What's the employee that Gaydos is in? You said they're not in the same employ. That's the premise of your argument.
Well, they're not in the same employ when Gaydos is interacting with his skid loader. Now, those are the facts of record in this case. In fact, Mr. Gaydos is stuck with all these facts.
Right, the reason I interposed that question is I think you're making it very clear, if I take your point, that the whole case comes down to the fact that they're not in the same employ. Is that my takeaway from the first few sentences of your argument?
Well, they're not in the same employ when the act or omission occurs, Your Honor.
And tell us, if you would please, then, what employ Mr. Gaydos is in and what employ Mr. Brown is in when this act or omission occurs.
Well, Mr. Gaydos, when the act or omission occurs, is pursuing his own interests. He owns the skid loader. He purchased it with his own money. He insured it under his own name. He does all the maintenance on it. And he does all of these things outside the scope of any connection to ACS. Now, Mr. Gaydos could have made this asset a part of his alter ego here at ACS. He could have done that. But for whatever reason, he chose not to do that.
So it's the title of the asset.
It's not the title, Your Honor. I mean, if you could assume that if he had made this an asset of ACS, we would not be here, because it would be everything that he did with the skid loader would have been in the furtherance of the interests of ACS. But we don't have that here. We have a man who has invested in this skid loader. He makes very clear that it's his instrumentality. He even delivers it to the site and tells the workers, and by the way, Mr. Brown wasn't there when he delivered the skid loader, and said, nobody can operate this skid loader but me. And he made that completely clear that it's his. And then he left it unattended and unsupervised, where it's clearly foreseeable that someone might have to get into that skid loader and interact with it and get hurt.
I mean, foreseeability questions and faulty equipment aside, I'm just trying to understand how Mr. Brown is not engaged in the same employ. I mean, Gaydos is the boss. That's why he says, don't use it until I come back. He's the boss, right?
Yes.
So how can you say they're not in the same employ? I'm not following that.
Well, that's because you have to look to the plain language of the statute. Okay, that's when you have to go to the plain language of the statute. That did the act or omission occur while in the same employ? And when you overlay Apple onto the case, first of all, and we'll start with Apple. We believe Apple's good law. We don't have any problem with Apple. It's the dicta that the defendants rely on about all employees in all situations. Unfortunately, in Apple, the plaintiff had raised an argument about scope and course, and argued that, well, they might have been in the course of employment driving to the same place, but they weren't in the scope of employment because they weren't teaching. And the Apple court said, no, that's no good. The holding in Apple is not all employees in all situations. I will read you the holding. It says, we entertain no doubt whatsoever that both parties were acting in furtherance of their duties at the time and in manner approved by the employer. That is the holding in Apple. And it goes on to call that a clear and simple test of the same employ. Okay, so by their reading, the Supreme Court's reading of Apple is that if there's no question that the workers are in the same furtherance of the interests of the employer, that's not a question like it was not in Apple, then the analysis is over. You have immunity. And Justice Weck, you've written that immunity should be generally broadly construed. You wrote that in the NWM case. And when you narrowly construe to these facts in Apple, you get an equitable outcome. That employee should be immune. However, when there is a question that arises, and by the wording in the statute, when it says while in the same employ, that means there has to be context. The condition of immunity has to have context. The defendant has to have control over the employee at the time that the acts occurred, and that the act or omissions occurred while in the same employ. And when you overlay that to the facts in this case, everything that Mr. Gaydos does with the skid loader is outside the interests of ACS. Arguably, the only thing he did in the interest of ACS was deliver the skid loader to the site that day.
I'm following you until you say outside the interests. And you can be in the employ of someone, you could be at the work site and acting outside the interests of the employer, but that doesn't change the fact that you're still employed at the time. The statute doesn't, to me, the statute doesn't inquire whether you're acting in the interest, acting outside the interest, in the course, outside the course. It focuses simply on, at the time of the act or omission, were you in the same employ? And that's where I think Justice Weck was going. At the time of the alleged act or omission that you're talking about here, which you kind of suggest that it was while he was on the job site, maybe that's part of your claim, but tell me what the act or omission is that you believe causes the liability here, and then say, and while that happened, Gaydos was the employee of X.
Sure. So it's the antecedent negligent conduct of George Gaydos that is.
Tell me in a non-lawyerly way. What was the act? What was the actor? I went to Harvard on the Susquehanna. What, you know?
It's his conduct before the skid loader is delivered to the site, and it's also after it's delivered to the site. So it's
Okay, so the conduct before it was delivered, what was it? And that occurred while
Sure.
Gaydos was the employee of X, and then the conduct.
yeah.
Connect the conduct while, boom.
When Gaydos was interacting with his skid loader before this incident, he was doing it, you look at the location, he did it at his own home. He was responsible himself.
Who was his employer at the time?
He had a sole proprietorship.
Okay, that's the answer.
Yeah,
It was just like-
it's a sole proprietorship that he, and keep in mind, Justice, that this skid loader is his asset at all times. That's completely clear. He's stuck with those facts. That can never change. So he maintains it at his own home. He bypasses safety mechanisms on the machine.
Your counsel, now let's focus on that. The opposing counsel argument is no, that cannot be the act or omission because maintaining a skid loader, deactivating a security device in and of itself is not negligence. The negligent conduct was the act or omission had to be delivering it to the job site and putting it into use.
Delivering it to the job site isn't a negligent act. I mean, the negligent act is bringing it to the job site and leaving it unattended and unsupervised and accessible to workers. That's the negligent conduct. Delivering to the skid loader.
So the antecedent conduct you were talking about is not the act or omission we're focusing on here.
I think it's a straight line that you can draw that starts before the accident and goes all the way up until the
Does
accident.
that mean that in Apple, the court should have been focused on whether Reichert or whoever the negligent driver was in that scenario had failed to service their car properly or had not put air in their tires, or, I mean, because your argument would seem to be injecting into the statute a temporal element where the court would be required not just to ascertain whether the people are in the same employ, but additionally to determine whether the act or omission had roots in some prior negligence as opposed to in the instant.
Thank you for the question, Justice. I think to answer your question, no, we're not asking for this complicated test or analysis. Those questions never came up in Apple. And in fact, in Apple, was decided in 1971, and for 37 years, there was no question interpreting Apple. And I think the progeny of cases that follow Apple, there's really never a question about whether the employees involved in those cases are in the furtherance of the interest of the employers in almost all those cases. It isn't until the Bell case that comes up in 2008 where the issue of same employee comes up in the Bell matter. And in that case, the court says, look, sometimes you might have a case because the defendant in that case tried to raise the co-employee defense, but it was waived because it was brought up late. But the Bell court said, well, look, if there becomes a question here about whether they're in the same, furthering the interests of the employer, then two things. One, first, this is an affirmative defense. So the burden is on the defendant in this case. It's an affirmative defense. And then you have to apply this simple test from from Apple. And the simple test is just what was the status of the defendant, and was he or her furthering the interests of the employer? That's all Bell says. And Bell reaffirms the reading of the statute and confirms the test in Apple. It's not all employees in all situations. In Apple, the Supreme Court said that in context to dealing with the scope and course argument that was raised in that case. And then at the end, they said, hey, when you don't have employees' conduct at issue in all employees in all situations, you have immunity. That's the true reading of Apple that's been turned into a chimera by the defendants here. So that's how this should be approached. And there isn't any confusion about how Apple and the statute should be interpreted until very recently. And it arose in the Evans case. And I would point out to the court in the Evans case, that's of course an unpublished opinion. But Judge Dubow, who wrote the opinion in the Evans case, subsequently joined the majority in our case with the Superior Court below. So I don't think that there needs to be all this confusion about the statute and about all employees in all situations. All we've asked, and it's in our brief, is that you read the statute as a whole, you give meaning and weight to every word in the statute. You can apply Apple. It's the first test. If there's no question about the furtherance of the interests of the employees, Apple holds. You get immunity.
If you prevail, counsel, would it mean that in all cases of workplace injury, Pennsylvania courts would need to ascertain the ownership of the equipment involved in the injury? I mean, there are all kinds of, as you know better than I do, there are all kinds of equipment leasing transactions and all manner of ownerships there. Would that be a layer of analysis that would be required if you prevail, that would go above and beyond ascertaining whether these people were in the same employ as required by the statute? In other words, here, I think you're suggesting that it's not just if Gaydos and Brown were in the same employ. You're also saying you're interested in the fact that this skid loader is owned by Gaydos and not by ACS.
Well, thank you for the question, Justice. This issue doesn't turn on ownership. It just, that's really not, it's a part of the analysis, but it's not going to turn on that analysis. And what I mean by that is that when we're looking at the factors around Gaydos that we've talked about, that he was maintaining it at home, that he owned it, that he insured it, there's a constellation of facts that you look at when you start to get outside the Apple analysis. Not every case is going to be the Gaydos case with these many facts that are involved. It's really no different than any court might do in a summary judgment motion. You're just going to look to the record and you're going to see whether or not there's a question. And if there is a question about whether this person is a co-employee, then that's reserved for the jury. If you follow the Gaydos reading here, not only is this blanket immunity that is absurd, right? We have the example in our case where you have a nurse that works for a big conglomerate hospital group. She's driving between point A to point B, two hospitals. Another nurse comes in who's not working, to bend to the bar, smashes into that nurse. Counsel said here today, you're immune. Now, that is an absurd result and an absurd reading of the statute.
You got to be careful about that because the General Assembly is allowed to craft clearly absurd statutes.
And indeed they do.
Yeah, it's only your absurdity argument only wins the day if you're going to argue that it's ambiguous.
Right.
So under my hypothetical involving the Chief Justice as the tortfeasor and myself, she would not be in the same employee at the time of the act or remission.
That's correct. Yeah, that it would be a question, Your Honor. I'm not saying that, yes, that's it. We would say it's a question of fact. And that's what we're asking this court here. We're saying, hey, this is simply a question of fact that a jury needs to hear, whether or not this person is a co-employee. And I'd also like to address what we consider to be a canard or a red herring that the defendants have raised since the very beginning here, and this is this dual capacity doctrine. The dual capacity doctrine deals with who an employee can sue. It has not one thing to do with co-employee immunity. We are under Section 72 here, talking about co-employee immunity. The reason we didn't address this doctrine is because it is so highly disfavored that nobody uses it. I think there's only 2 or 3 cases that even talk about this doctrine. We never sued ACS. We never did that. If we were trying to sue ACS, that would be a dual capacity doctrine claim, because we'd be saying that ACS is wearing 2 hats and we're trying to sue ACS.
Dual capacity focuses on the employer, not the co-employee.
Exactly. And they've raised this argument repeatedly and confused the courts by arguing that it's our burden, And they've inverted the whole argument and turned it inside out and now say it's our burden. This is an affirmative defense that falls upon the defendants here. And it's very important that this court hears this case today and makes a decision about this, because from our perspective, there's no other way to read the statute. It certainly requires conditional immunity when there's a question about whether or not the defendant was furthering the interests of the employer at the time.
Okay, any other questions? Thank you both, very well argued.
Thank you.
Thank you, Your Honor.
Mr. Minner, would you call the next case?
Housing Authority of the City of Pittsburgh versus Darlene Nash. Representing the authority, Mr. J. Andrew Salem. Representing Ms. Nash, Mr. Daniel Stowe.
Good morning.
Morning, Your Honor.
In this discretionary appeal, appellee Darlene Nash was throwing an open house party at her apartment in a public housing complex in Pittsburgh when one of her guests shot and killed another guest. Pursuant to the terms of her lease with the Housing Authority of the City of Pittsburgh, this incident was a material breach of the lease and grounds for termination if the shooter was on the premises because of an invitation from Nash. We must determine whether an invitation to an apartment unit constitutes an invitation to the premises as a whole, providing grounds for eviction under the lease. And it may be more nuanced than that, and I suspect you'll enlighten us.
May it please the court, Andrew Salem on behalf of the Housing Authority for the City of Pittsburgh. Your Honors, the Commonwealth Court's interpretation of the lease language at issue in this case is, to put it simply, wrong. Number one, they assumed that there can only be one invitation and only one reason for the invitation to be on the premises. In addition, they held that you can be invited into a unit, into the apartment or into a house, but not be invited to stay or remain on the premises. But that is actually a physical and logical impossibility. And I'll give an example to illustrate the problems with that analysis. Say, for example, I have friends who live in Unit A and friends who live in Unit B, next door neighbors. My friends in Unit A invite me to a birthday party, and my friends in Unit B for the same day invite me to go and watch a sporting event. I go to Unit A, attend the birthday party, I leave, go next door to watch the sporting event. And while I'm watching that sporting event, say I get in a fight, I assault somebody. I've beaten somebody up. Under the Commonwealth Court's interpretation, the person who is in Unit B, who lives there, the tenant who has invited me there, cannot be evicted because I was previously invited onto the premises by the person who invited me to the birthday party.
Your facts are, your hypothetical varies the facts of this case, doesn't it? This shooter, Ty, we'll just call him Shooter maybe. Shooter is a frequent guest at the other unit, the one that's inhabited by his girlfriend and his baby. Is that right?
Well, Your Honor, this is another issue with the Commonwealth Court's interpretation. They viewed the evidence in a light most favorable to Miss Nash, okay? And at the Commonwealth Court level, they were the appellant. So if you actually look at the evidence in the light most favorable to the housing authority and the evidence that was presented, there's no evidence that the girlfriend invited the shooter onto the premises. It's speculation, just speculation, and that's what happens. But the trial court never makes that determination. It never makes a finding of fact and says the girlfriend invited the shooter onto the premises.
Well, he didn't need a specific invitation each time he entered her premises if he frequently entered the premises, does he?
No, he would not. But that's why there's different definitions. You can be a tenant and you can be a guest. So he could be a guest of the girlfriend, but not be a guest of Miss Nash. But
that you just put your finger on, I think, a key aspect here, because you drafted the lease. Nash didn't draft the lease, and you used the words premises with respect to invitation, not unit. Had you used the word unit in your lease, we wouldn't be here. She'd clearly lose the case, right? But you used premises vis-a-vis invitation, which is an entirely different matter than unit, isn't it?
Not exactly. So first, as it relates to the drafting of the lease, I want to point out that this is a housing authority lease, so it's governed by federal regulations. So we have to follow federal definitions. So we can't just willy-nilly change the language of the lease.
We definitely can't. We agree Nash can't change it.
Correct. Yes. But the definition of premises is broader than the definition of unit. So while they're not the same, and we admit that, they're defined differently, but the definition of premises includes unit. It says the building, the complex, or the development in which the units, as defined below, are located. You cannot enter a unit and not be on the premises, but you could.
Well, let me one more interruption, if I may. Pardon me. So following that reasoning that you're going through there, I don't think there'd be any distinction in the scenario where Ty, the shooter, had on the way to her party in the hallway, shot the victim and killed him or injured him, whatever. The point being, Nash, under your understanding then, Nash is liable there too, even if shooter's not in her unit, right? Because it's indistinguishable.
Well, the hallway, as defined, is actually included in the definition of unit, and it's also considered on the premises. So, if it's the hallway, the lawn, that's considered part of the unit. It's also part of the premises. So the question is whether at the time of the activity, why are you there? Okay, and that's something that the trial court relied on, but the Commonwealth Court ignored. So as part of the definition of an other person under the tenant's control, it includes that phrase of at the time of the activity. And that's why I gave the example of where there's multiple invitations or there's multiple reasons for being on the premises. The question is, at the time of the activity, why are you there? And at the time of the activity here, the shooter, at the time he unfortunately kills the individual inside Miss Nash's unit, the reason he is there is because he's attending her birthday party. So the reason that he is in the unit, the reason he is on the premises at the time of the shooting is because of Mrs. Nash's invitation. Now, he could have another reason to be on the premises, but it doesn't matter at the time of the activity he is also on the premises in the unit because of Mrs. Nash's invitation, which is the case here. There's not a dispute, at least at this point, there's not a dispute that the individual who was killed inside the unit.
Was there any testimony in the trial court that the shooter saw the Facebook post invitation?
There was no testimony as to that, Your Honor.
Was there any testimony specifically at the trial court level that the shooter was invited?
There was testimony about that was based on inferences. There was testimony that he frequented Mrs. Nash's apartment, that he ate there, slept there on occasion, and took showers there. She said she knew him. There was testimony, in fact, that he had come into the apartment during the birthday and ate birthday cake. There was no specific testimony anywhere that said there was like a physical invitation handed, and because he was on the run, obviously there was no testimony from him of I was invited or I saw the Facebook post.
It was an open house, right? So does that mean everybody's invited?
Not everybody.
Everybody that's on her list of Facebook friends.
Well, everybody who comes to the party who she sees and doesn't say, get out, basically.
You just made her, in response to the chief's question, you've just made Nash the guarantor of safety for the entire project. So that entire set of buildings, she's now the guarantor, having put on social media an announcement of this open house. Anybody venturing in there who does any mischief or harm or crime, she's on the hook, because she put on social media that she's having an open house. Now she's subject to eviction based upon actions of people that she doesn't even know.
That's correct, Your Honor. And if you look at other provisions of the lease and the way the housing authority leases are because of federal regulations, that's how it's supposed to be, because the policy reason behind these is it's heavily related to drugs and violent crime. And so you can be evicted because somebody who was your guest committed a drug offense and it wasn't even on the premises. So it's very broad, but the reason for that is to provide for a safe area in these housing units. So there's extremely broad authority in terms of the way the federal regulations and federal statutes are set up to protect against violent crime and drug dealing and things like that. So even if there's a person, it may seem unfair, but the idea is we want these residences and residents of the entire area to be safe. So yes, the answer to the question is she responsible? Yes. Now that might seem unfair, but there's a reason behind that, the language and the regulations that are in existence.
Was this a closed community?
So it was Northview Heights. So it's I don't want to say it's a closed community, but there's I'm not sure I understand what you mean.
Did it have a security guard to enter the premises?
No, it's not like a gated community. No. So my understanding is that this also wasn't like an apartment building. It wasn't like where you'd go up in an elevator and there'd be units all through the floor. They were like houses.
So what would happen if the shooter was also a tenant, under your theory? Who gets the victim?
Both, Your Honor. A covered person includes tenant, guests, and other persons under the tenant control. And that other person under the tenant control is sort of the catch-all. It's to catch people who don't fit under the tenant and guest category.
Was there any evidence that Mrs. Nash did not invite him? Did she maintain that she did not invite him? I know you said there wasn't really anything that said she did, except posting the open house notice. Any evidence that she did not invite him or that she disinvited him?
There was no evidence that she didn't invite him or evidence that she didn't invite or disinvited him. The evidence that she testified was about, well, he's always on the premises because his girlfriend lives next door, and so he's frequently here.
I thought it was her position that someone in her family had posted the quote-unquote open invitation.
I believe it was both.
Didn't agree with it, and she didn't like social media, and she didn't like people using it as much as they do.
Well, my understanding, the evidence was that she did not post it herself, but it was either her daughter and friends, both, who posted
She didn't know about it until the next day, she said. Now, the trial court didn't believe her, as I understand his opinion. He didn't find it credible?
Well, the trial judge doesn't come right out and say, I find this testimony to be incredible, but the inference is there as it relates to the way that the trial court made its determination.
Isn't that important, though? I mean, I sort of read the trial court opinion to read that he didn't find it credible, that she wasn't, she didn't know about the social media postings, didn't know about that invitation going out. But if he didn't make any finding on that, where does that leave your case? Where did the invitation come from then?
Well, what he said was that there is an inference that he was invited because anybody who came in and celebrated, other than the victim, because there was testimony that the victim had been disinvited.
But Nash had to invite him, correct? I mean, it wasn't just, it had to be Nash who made the invitation under your...
Yeah, but it doesn't have to be, there doesn't have to be in all circumstances, a direct invitation. I don't have to call you on the phone and tell you that you're invited.
Did Nash's girlfriend get evicted, considering the inference that you just shared with us?
So she moved away. The girlfriend,
Or after? The shooter's girlfriend.
the shooter's girlfriend, my understanding was fled and was on the run with the shooter at the time. I don't know what happened afterwards.
The authority moved to evict her, even though she ran away. She still had a tendency with the authority. Did your organization move to evict her as well, based upon the facts you just shared with us, that he has a baby with her, he stays there, and the inference, as you indicated, is she invited him there, and he ended up shooting someone while under her invitation, since this record's conspicuously absent as to Mrs. Nash's invitation, as foretold by my colleagues. So I'm asking you.
I don't know.
Why would the organization not apply the statute by evicting the girlfriend?
So I don't know as a factual matter whether they moved to evict her, but all I know is that because she was no longer there, so I don't know the answer. But what I can say is, could they have? And the answer to that is yes, they could have not only evicted the girlfriend, they also could have potentially, again, there would have to have been evidence of this, and there wasn't in terms of the testimony. The girlfriend wasn't the tenant of the next door neighbor. She lived with her sister. So that would be the possibility. But there wasn't, like I said, there wasn't testimony concerning that. So, but...
Can we get back to fleshing out a little bit where the invitation by Nash arises in this case? Does it arise from the social media post?
I don't believe so.
Where does the invitation come from?
I believe the invitation arises from whenever she sees the individual and that person is inside her unit or inside her apartment or house and is celebrating the birthday and is being served birthday cake or whatever, like, you know, that is an implicit invitation to be at the birthday party and be inside the house.
So you would have had to ask him to leave, physically have him removed, or something of that nature to get off the hook for the subsequent shooting.
That is our position, yes.
Yeah, I'm a little lost on the invitation issue myself, because to my mind, it doesn't make a difference who invited the person into your property. If somebody walks in your house and you greet them, you allow them to stay. The issue, in my mind, and the issue according to the regulations is that person under your control? So if you allow somebody entry into your property and allow them, or even if you don't allow them entry, but you allow them to stay, aren't they implicitly under your control?
They're not necessarily, well, if they're trespassing, they're not under your control. But if you have,
That's not the fact pattern. The fact pattern is he showed up at a birthday party.
Yes.
She knew him. She greeted him. She knew he was there. He had a piece of cake. She allowed him to stay. Isn't that implicitly under your control for purposes of this particular regulation, or does the invitation mean something different?
our position is that is an implicit invitation, and the reason for that is because the definition of other person under tenant's control requires an
I'm
invitation.
asking the question because we're hung up on this, who invited the person into the property? If the guy showed up at his girlfriend's house next door, saw there was a party in her place, walked in, she greets him, says hello, at that point, isn't he under her control for purposes of these regulations? He didn't even get an invitation.
Well, our position would be that he is under her control, but the reason that he is because she's accepted him and impliedly invited him in.
That's what I just said. So the invitation issue is really irrelevant.
You need an invitation under the lease, correct? You need an invitation.
Under the lease, yes, under the lease language, the definition of other person under tenant's control includes an invitation. It doesn't, but it can be an implied invitation.
But I think Justice McCaffrey's question is helping you.
No, I'm not disagreeing. I agree with.
If I understand,
I was trying to anyway.
If I understand the takeaway, you're saying it doesn't have to be an engraved invitation. It can be a purely circumstantial invitation, like, "Hey Joe, have a piece of cake," or like anything short of kicking the guy out and saying you're not invited, right?
Yes, Your Honor, and I'm not. I agree with that, but I have to concede what the lease language says. But I 100% agree that you, by inviting this person in or the person coming in and you welcoming him, that is in fact an invitation.
It's also under their control.
Greeted him? I'm sorry. Is there evidence that she greeted him and interacted with him? I thought it was just that he was there and he had a piece of cake.
She testified that she was aware that he was there, and obviously she knew him.
That she greeted him. Okay.
She didn't throw him out, though, either.
She certainly did not throw him out. The only person who was thrown out was the victim.
Thrown out after he was shot
That's literally true.
into the hallway.
Correct.
How many people were at the event or at the party? Is there a record?
There's not anything in the record that is specific to the number of people who were there.
It's quite a burden to place on the birthday girl to identify everyone who's coming in and make sure, oh, that's not my sister's friend, or my niece invited that person, and so he must be welcome here. How does the home renter determine, or how does she meet that burden of scrutinizing every single person that comes into the open house? Could have been 50 people, I don't know.
Yeah. So I'm not disputing that it could be difficult, but that's how it has to work in terms of keeping things safe in the public housing authority arena.
The federal funding stream is reliant on tenant policing of invitees.
Exactly, Your Honor. Exactly.
That's a good.
And the other thing to remember is that it doesn't necessarily automatically lead to an eviction. They may be evicted. Now, the original presentation of evidence in this case was also that the shooter in this case was a guest, that he lived there. The trial court said, well, I don't agree that he lived there based on what you've presented, but I do agree that he was under her control for these reasons.
Occasionally slept there, right?
That was, yes.
And the way these things are supposed to work is the MDJ is going to have a hearing, and then it goes to arbitration from there and follows the course it followed here. I mean, these are very fact-intensive adjudications, aren't they?
They are, Your Honor.
All right, any other questions? Thank you. We'll hear from
Thank you, Your Honors.
opposing counsel.
Good morning, Your Honors. May it please the court, Daniel Stoner for the Aplt, Darlene Nash. I think first and foremost, it's important to know that this is really a pretty simple case. This is about a contract at the end of the day. It's about a lease contract, and it's a very clearly written contract. I would say for a residential lease, this goes into excruciating detail as it defines these things. So it states very clearly the circumstances where a tenant can be evicted. It states very clearly the circumstances where they can be evicted for the criminal activity of a third party defined as a covered person. And it very clearly defines what another person under tenant's control is. And it states that they have to be on, at the time that the act in question occurred, on the premises due to an invitation of the tenant or a member.
Didn't Judge Connolly make that determination as a matter of fact in the trial court?
No, he did not. Judge Connolly found that he could make no factual determination that the shooter or the purported shooter was on the premises that evening because of an invitation from Ms. Nash. And I think that should have been the end of this case right then and there. He did not fit the questions of fact that need to be answered in this contract to actually find her liable under these terms. If he's not on the premises in question because of her, then she cannot be found liable for the criminal act. He's not another person under her control.
Counsel, I thought Judge Connolly really focused on the all comers welcome social media post.
Yes, and that's what
How is that not, he didn't answer this question?
Well, he decided to create an entirely new standard of an open house standard that's not contained in the lease. There's nothing in the lease that talks about that.
Well, she decided to have an open house.
Well, that's true. But I don't.
It's a great way to avoid liability by having an open invitation not directed at any particular person and have no responsibility for anybody that comes.
Well, that could be true, but I think you have to think about the implications of all of this. If we're going to have an open house exception that's going to make people liable, I mean, that's going to cover things like neighborhood meetings, Bible study groups, a children's Easter egg hunt, block parties.
There's the additional circumstance, and I don't know, perhaps this is why Judge Connolly deemed the shooter a covered person under the agreement, was that the shooter was in her unit for this event. He was in her unit for the event, and although I guess he didn't say it in his verdict or his opinion, wouldn't that be a difficult obstacle for you to overcome here?
Well, I think that there's a reason why the lease clearly differentiated between the premises and the unit, and particularly, for these types of things, when you have these community-oriented events that are an open house per se, if you look at the federal regulations that this is based off of, you look at cases like Department of Housing and Urban Development versus Rucker, they make it pretty clear, what the rationale is behind these laws. So it originally came from the Anti-Drug Abuse Act of 1988. It was subsequently expanded to include pretty much all forms of violent crime. But the basic rationale is, even if you're not committing crimes, if members of your household are, or guests who are frequently over are committing crimes, and you're not doing anything to stop that, you're just as much of a threat to the community as these other people are. And that's why you should be.
Added the word frequently. Where did that come from?
Well, I mean, with somebody, if they're on the premises at the time because of an invitation of
That doesn't mean
yours.
they're frequenting the premises.
Well, no, but basically any kind of guest. I mean, it's pretty broadly worded how they have it.
But it's not only a guest, it's an other person under tenant's control.
Yes.
I mean, it's not limited to guests. What you're describing is a guest.
Yes, you know, but I would say that, you know, that they put the wording premises there, it's there intentionally. Once somebody is within a housing complex or within a project or an apartment building, they may wander around and go to other places. And really, I mean, in these actual regulations in the case law, they talk about, you know, why they're doing this is because of the impact that criminal activity has on the community itself, the so-called reign of terror.
This premises focus that you have, why shouldn't we interpret the word premises broadly? And it was intentional because maybe I didn't invite somebody to the unit, but I was having a party in a common space. And that's why they chose to use premises, because they want to encompass not only if you invite somebody to your unit, but you invite somebody to a common area. That's why they didn't say unit or premises. They said premises, which is defined to include unit. So they intentionally used a broader term to encompass all possible circumstances where you were invited.
And that's true, but I think that if they were to say that you can assume all liabilities simply because they come into your unit, it would have been clearly stated in there. This is a very clearly written lease.
I mean, this is not that bizarre, right? I mean, premises liability, if you invite somebody into your property and they get hurt on your property, you could have premises liability. This is not that bizarre of a concept.
Well, and that's true. I would say, you know, as far as the context of open house community type of events, I mean, these are really the types of things that the statute, these regulations are meant to protect. It's to protect this sense of community, so that if somebody, like I said, wants to have a neighborhood meeting or a Bible study where all are welcome, why should they be assuming the liability?
I mean, where are you conjuring that intention from? I mean, it seems that the purpose is entirely the opposite. It's to protect the community from wrongdoers coming in, not to well, put that aside for a moment. Here, the fact-finding is important, and although the fact-finding maybe could have been a little more conclusive one way or another, the court did say, in its opinion, trial court, anyone who did come to the property was greeted as a welcome visitor. That's based on Nash's testimony. And he goes on to say, anyone who would show, or she assumed the risk of those guests' misbehavior. So the problem you have is the trial court relied on Nash's testimony that even though she didn't know this guy was showing up or that he was going to get violent, he was welcome, as was anybody. And that's the basis, I think, that's the basis why the trial judge said that this was an other covered person. So aren't you just asking us to rewrite this lease, which comes from HUD language?
Well, I think, you know, what the housing authority is actually doing that. Because they're trying to put terms into this contract that don't exist. There's nothing in there about an open house exception. And I think that's done.
Why are you saying an open house is an exception? If I have an open house and I'm selling my property and people come, if they get injured, I'm responsible. I opened my house to anybody that came. And if I have a negligent condition on my property that causes somebody to get injured, I don't get to say, well, they were trespassing.
Well,
because I didn't specifically invite them.
That's true for the purposes of, you know, a tort action for premises liability.
Well, this isn't criminal. She's not being held criminally liable here. This is administrative civil liability. It's relatively indistinguishable from tort. She's being held civilly responsible for an act of someone who came to her open house.
Yes, and that's true, but the only responsibility that she has for these things is determined by the contract itself, and the contract is very clear. You need to be bringing this bad person into the community, onto the premises for this really to count. They actually have to be on the premises itself, and I think it specifically is done that way because there are many different types of social activities where there may not even be somebody necessarily in charge. If you have a neighborhood block party.
Lost me. I thought we had established through this argument that the unit is part of the premises.
Well, the
They're
unit,
still maintaining it's separate.
I would say that it's separate. I mean, it's the unit is within the premises, but I wouldn't say, I mean, if somebody is invited onto the premises because of somebody else, and in this case, it was probably his girlfriend who lived next door, who had his child, that would seem to be the main reason.
You have no evidence of that.
Well, there was a findings of fact at the court here. There was no findings of fact that he was here because of Miss Nash. I do not believe he would be. Why would he be here for her and not his girlfriend and his child who were next door?
Justice Fleck just read you from the trial court's opinion where they said that he was in the unit. There was an open invitation. He was in the unit. All were welcome. She greeted him. I don't know why you're injecting this alternative theory that, oh no, because he was spending part of his time at, you don't know that he came from the girlfriend's unit. You don't know, I mean, is there evidence that that's exactly what happened? That he was invited, he was in his girlfriend's unit and said, oh, I hear there's a party down the thing, I'm gonna walk down there and get a piece of cake? I mean, was there evidence presented that that's how he got to the unit?
There was certainly evidence that he was there not because of Miss Nash, but I would say those are questions of fact, which the court has already answered, and they have determined that, and the court explicitly said they could make no finding of fact that he was on the premises because of Miss Nash.
That is a problem, is the court couldn't make that determination and said, but he did say it was unnecessary. And
Yes.
he said it was unnecessary because of this open house phenomenon and her saying everybody was welcome. But you're saying there's an initial problem because the housing authority did not establish that this guy was on the premises at her invitation.
Yes, and that's what I mean when I say that the court was trying to invent some entirely new legal standard here with an open house rule that's not in the contract at all, and these contracts need to be strictly construed as a contract of adhesion, and it's not ambiguous whatsoever, and it's very clear.
Is it the housing authority that's trying to create the open house exception, or are you trying to create the open house exception?
It's the housing authority trying to create that. I'm trying to say by the rules of contract interpretation, they did not meet the fact burden to show that she violated this lease, that he was another person under her control.
If a business advertises an open house and someone comes onto the property and gets injured, they're not a business invitee?
I mean, they could be considered a business invitee, but I'm not aware of many circumstances where a business is going to have strict liability for the criminal acts of that person.
But invitee, invitee is not defined, the word invite is not defined in the contract, right?
Yes. Well, and
so we have to ascribe it its ordinary meaning.
That's true, but the contract also makes exceptions, saying, for example, you have a plumber onto your in your place and he commits a crime there. That's explicitly not included as another. So they're not saying every invitee.
There's no exception for an open house.
There's the word open house is not in the contract at all.
You see, I think your argument is very interesting because it's a legal argument here, I think, that their contract, not your contract, their contract says the other person under the tenant's control definition is a person who's on the premises because of an invitation. And your point is, I think, tell me if I'm wrong, that there's no fact-finding here. There is no fact-finding here that this guy was on the premises because of Nash's invitation. And that is a necessary condition for the breach of lease. Isn't that the point?
Yes, Your Honor. That's exactly correct. That this is a question of fact. Whether someone is another person under tenant's control is a question of fact, and that question of fact, we put this to trial, and the court could not make that fact determination.
Counsel, the lease says who was at the time of the activity in question on the premises.
Yes.
If a unit is part of the premises at the time of the activity in question, thus shooting, he was in Nash's apartment by her invitation. I mean, I don't understand this notion of having to trace, you know, to the original point of entry onto the housing authority's property as being the moment that you have to identify the inviter. Because this talks about who at the time of the activity in question. The only activity in question here is the shooting.
Yes, and that's true. I mean, I would say that that it says they need to be on the actual premises because of that. I mean, there's nothing in there.
The time of the activity in question.
Yes.
Is the shooting.
Yes.
Which is in her unit, which is part of the premises.
And that's true, but the trial court still couldn't even make that fact. They explicitly said we can make no fact determination that he was on the premises that night or the time of the shooting
But as
because
a
of her.
proposition of law, you're arguing that in a case such as this, as a proposition of law, it is a necessary fact finding for the fact finder to say whether the invitation to the premises came from this tenant.
Yes, that's what I would say, and I think that this actually comports with the regulations, with the legislation that these provisions were based off of, and that these are people that if somebody is coming into these places, into the communities and causing crimes, that the people who are the reason for that person, why is this person here? Why was that person there that night? And we're saying that the reason why the shooter was there that night was not because of Miss Nash. He was there because he was visiting his girlfriend and saw there was a party next door.
Here's my concern. Could I just follow up on that? Here's my concern. You're talking open house in terms of maybe the shooter was just a stranger who wandered in. This is not that case. Mrs. Nash testified that she's known the shooter since he was a kid, that he's eaten at her place, slept at her place, keeps a bag at her place. It's a stretch then for me to say he wasn't invited.
Well, I mean, I would say there's nothing in the lease saying that, you know, even if you were to invite somebody onto the premises, if you knew them or not, I mean, if they committed a crime, you know, I mean, this is considered strict liability under the contract. I think that the issue that I have is trying to conflate the unit with the premises for this particular question. And if we do that, then you open the door about what about a prayer group or a neighborhood meeting or any of these types of things where traditionally all people could be able to come. Now you're having all this liability that, first of all, is nothing in the contract that states that. But I think it goes against, you know, this law was about stopping what they call the reign of terror. And if you want a great thing for this, in this particular case.
A couple hundred years late for that.
There were 24 people at this party, Your Honor. They saw this man get shot right in her room. Only one person gave a statement to the police, and that was my client. And she's the one getting punished by this, which I think is pretty perverse.
Well, your client also instructed people to carry the body out of the hallway.
He was still living at the time, and they did call for the ambulance. But I will say that you know, not a single person except for my client spoke to the police. And the reason for that is because of fear, because they know what happens if you're labeled a snitch in a place like this. And this is exactly the reign of terror that the federal legislature spoke about, that the Supreme Court talked about. This is exactly what these things are supposed to stop, and they're supposed to be able to allow these people to have some measure of community, and that includes being able to have an open house party, to be able to do these things.
Your use of rockers, that goes against you. The strict liability effects. Therefore, as a tenant, him being invited, she goes. So I'm kind of confused why you're arguing rocker strict liability to protect you when I'm finding those facts hurt you.
Well, with the case with the Rucker case, I mean, they were looking at the actual terms of the contract and the facts in that case. I mean, there was no question that per the terms of the contract, this was somebody under their control. There is a very real question in this case because there are factual questions, prerequisites that need to be answered, that the court did not make those findings of fact. And if the housing authority wants to include these things, I think there would be a lot of flaws because of the effects that it would have on open invitation community activities. But if they did want to do that, they can put that into these leases. They can say that they can say unit and the premises are seen as one and the same. But they didn't do that, and this was very well defined. And I would just say, I mean, Pennsylvania, we're a plain meaning and intent state when it comes to contracts. And so I don't see where we should be deviating from that. There's nothing in here about an open house exception, but if there is any kind of ambiguity as to whether a unit is different from the premises, it should be resolved in favor of the person who didn't draft this contract. And it's a contract of adhesion.
Counsel, I keep getting back to this notion that you're reading out part of the language of this provision, which is the part that says at the time of the activity in question. I mean, you're reading this as if it says who was on the premises because of an invitation from the tenant. But that's not what this says. I mean, this allows for the possibility that someone makes an original invitation onto the premises. Like, for example, somebody else's unit. But then they leave and they go to the next door neighbor who invites them in. And at the time of the activity in question, the shooting, they're in that unit of the second person who came in contact with the person who was invited onto the premises. Why do we have to exclude the possibility that we look to the place where the activity in question happened?
Well, I would
Who
say
invited the person there?
I would say that's an important question because that person is the reason why that person is on the actual premises there.
No,
So
the person is in, the shooter is in your client's unit because she invited him to be there. So at the time of the shooting, he was in her unit at her invitation. I mean, how do you read this provision otherwise?
well, the way that I would read it is it's why was he on the premises itself that night? Who was he there for? And
so it doesn't matter, the activity in question doesn't matter in your reading of this provision of the lease.
yes, I mean, I would say if you're dating a criminal who shoots people and you invite him onto the premises and he walks into somebody else's unit and kills somebody, you should be the one that's at fault here. You should be the one. They didn't evict her. They evicted my client, who was the one who was having an open house party and also was the only one who even gave a statement to the police. But that's what I would say. I mean, I don't think that there should be any kind of liability that's conferred by somebody that holds these types of open house community-oriented activities where all are welcome. And I think that there's very real public policy reasons why we would not want to create such a standard. And it certainly seems to go against the spirit of what these federal regulations that these clauses are based on.
Thank you, Mr.
meant to
Stoner.
do.
We understand your position. Are there any other questions? No. Thank you very much, both
Thank you,
of
Your Honors.
Mr. Minner, would you call the next case?
Interstate Gas Supply versus the Public Utility Commission. Representing Interstate Gas, Mr. Todd Stewart. Representing the PUC, Ms. Anthony Tran. Representing West Penn Power, Mr. Devin Ryan.
Good morning. In this appeal by allowance, we consider whether electrical distribution companies are permitted under the Public Utility Code to deny electrical generation companies the ability to bill for additional services that the electrical generation companies offer their customers, even though the electrical distribution companies include customer charges for their own additional products and services on utility bills they send to customers. Please proceed.
Good morning. Oh, yes.
Still morning.
May it please the court, my name is Todd Stewart and I represent IGS et al. They're all electric generation suppliers, as you noted. With me today is Melissa Chapaska, who's an associate in our firm. The Public Utility Code has two separate provisions that prohibit utilities from providing discriminatory service. One is Section 1502, which prohibits discrimination by a utility in favor of any person. Then the second one, and any discrimination. And then the second one is in Section 2804 sub 6, which requires utilities to provide distribution service, in this case is the applicable service, distribution service on terms and conditions that are equal to its own use of its system.
But why is any of that applicable? You're talking about, those relate to service. And here we're talking about products that your client sells that are ancillary: surge protection, line repair programs, outdoor lighting, professional tree services, insulation products, disaster protection plans, lighting and smart home products, electric vehicle charger lease. It sounds a lot like the kind of things they try to sell you when you buy a car, like service plans and such. So why do you get to bootstrap yourself into electrical service when we're talking about these commodities that are separate?
The service we're talking about here is the billing service. We're not talking about all the ancillary services that are being sold. We're talking about the billing for those particular services.
But you want all of those things that Justice Weck just mentioned to be listed as services that are available on the bill.
Correct. The utility lists those services on the bill for its customers. We are required, the generation suppliers are required by the statute, if they want to have a single bill that has all the charges for electricity, that would be the commodity and the distribution and transmission on one bill, it has to come from the utility. And so the suppliers have no choice. If the customer wants to have a single bill, they can't bill these charges on the utility bill.
But some of them, quite frankly, have nothing to do with the distribution or generation of electricity. I mean, are you going to add carpet cleaning and, roof repairs? Some of these just don't have anything to do with what we're talking about.
Utilities have been providing these types of services on the utility bill since before competition. It goes back before I started practicing law. And there's a section of the Commission's regulations that deal with the billing of these services.
Is there any limit on what kinds of services you can come up with?
No.
So it's obviously not convenient for your client, but does that make it discriminatory within the meaning of the statute and
the utility is providing a service to I'll step back a second. When the section 1502 has been in the Public Utility Code since it was codified in 1978. Section 2804(6) was added as part of the Competition Act. It's in that act when the whole industry was restructured, it allowed the utility to have two distinct roles. One is a competitor, and one is the I will say the neutral provider of utility service, including transmission, distribution, and including billing service. And
But why would billing service not be for utility services? I just don't get that.
I think that the point here is not necessarily that it's not for utility services, it's that they're billing for a service. The Section 2807C says that the utility shall be the biller of all services regardless of the provider.
That particular section says quote electric services, I believe, and so by definition that sets up an opposition between electric services and the products that you're trying to include here, doesn't it?
Not necessarily. Electric services, in this case, if the electric utility is providing these services, I'm going to come back to this again. If the electric utility is providing these services, it's required to provide the service on rates, terms, and conditions equivalent to its own use of the system. That's what Section 2804(6) says. That's an affirmative requirement for the utility to provide the service on the same terms and conditions. If it's billing for car washing service, It should provide that same ability to bill to the electric generation suppliers who are serving the same customers on its system.
I understand what you're saying. I mean, if the EDC is providing car washing services,
Right.
and an EGS is also providing car washing services, the EDC can't include on the electric bill the added charge for car washing services unless it also includes an EGC's car washing service. That's your point.
Right.
My question is, again, I think Justice Wecht raised this. How is this discrimination where it's the General Assembly that made the EDC the biller? Isn't this just part and parcel of the ramification of the policy choice the General Assembly made and said, you know, we're going to have the EDC send the bills, and this is part of the benefit that they get is they can send bills that have, they can include one. There's nothing that says they can't, and it's just if the General Assembly set up this ability and they didn't prohibit it, your clients needs to become an EDC.
Well, they can't.
Well, I know, but I'm just saying, it's to me when I read this, it seems like your gripe really is with the General Assembly, that unfortunately EDCs have this added benefit because they're EDCs.
I'd say that it's the opposite of that. I'd say it's an added obligation to provide the same service that they provide to themselves. If they're doing it, if they're allowed to do it, the law says they have to provide it to everybody else.
Well, are all of these services that your clients are seeking to advertise services that are already provided by the electrical distributors, and are they already listed on the bills? Because it seemed to me they went beyond even that.
The utility provides a wide range of services. I can't sit here today and say that they all match up exactly, but I can say that
You can't make the argument that if they do it, they have to do it for us too.
the point is that these non-commodity products and services as a group are being billed on the bill. It's the billing service that we're talking about, the discrimination, not the services.
In response to the Chief's question, you did prove at the Commonwealth Court, it hasn't been disputed that some of the services that EGSs provide overlap
Some of them,
and your
Quite a
point
few.
would be, I understand you're making this broader argument that as a package you have to do it, but if you got even more narrow, you'd be okay with that. Like if the EDC is billing for tree line cutting services, you should be able to bill for tree line cutting
Correct.
services.
Well, that may be a fairness argument to make to the General Assembly, but I haven't seen a single statutory provision where the General Assembly has chosen to address non-commodity goods and services, whether in a discrimination context or any other context. I mean, in other words, this is a set of products that you want to sell, you do sell, and that you're, I guess it seems, I come back to this bootstrapping concept because it seems like you want to bootstrap this constellation of products into electric services so that the EDC has to treat your side businesses on the same footing to sort of help you compete with them. Or what am I missing there?
You're not missing anything. The point is they provide these services, whatever they are. It doesn't really matter what they are, but let's say they provide the same. They provide a set of services that we'll call set A. My clients provide a set of services that are set B. There might be 90% overlap. There might be 10% overlap. It doesn't matter. The utility bills for its set A products and services. My client is saying you should be billing for my products and services because it's the billing service that is the public utility service that has to be provided on an equivalent basis. It's not the products and services that have to be equivalent. It has to be the billing service.
What is the discrimination, that your client has to separately bill?
My client is required then to send an individual bill to their customers, and the record in this case shows that customers prefer to get a single bill, and that if they have to take the services on a separate bill, they're less likely to purchase it.
Yeah, but there's two ways to address discrimination. One way is to address it the way you want to raise it. The other way to address it is to say to the EGCs or the EDCs that you have to separately bill your products, in which case consumers get 3 bills.
Depending on if you would have to bill for the utility services and the generation service and the products and services, yes.
But because there's nothing that requires the EDC to put these non-commodity, non-regulated products on their bill.
That's correct.
So they are taking advantage of the fact that they are, as the General Assembly has set the system up, the EDC.
Yes.
Okay, so if you're right and this is discrimination, you would agree that one way to address it is to say to EDCs, you can no longer bill non-commodity services unless you also bill for the non-commodity services of the electric generation companies.
I agree with you, and that's what the commission did in the Columbia case 2 years earlier. They said, you, Columbia Gas, can either bill for these products and services for everybody on equal terms, or you can't do it at all. And that was the response. That was the commission's
You'd
work.
have to send, instead of the consumer getting 2 bills, the consumer would have to get 3.
Yes.
So I'm not sure how that's, if we're talking about discrimination and being fair, how it's a fair thing to say, right now the status quo is the consumer gets potentially 2 bills.
Correct.
1 from each company. You're saying that a fair resolution of this would be, oh no, now we want the EGSs to send 2 bills and we continue to send 1.
Well, the EGSs would still send 1 bill. The utility would be required to send 2 bills.
No, the EGSs could say, well, we're not going to bill for the EGSs. We're going to separate our bills, and now we're going to send 2 to our customers. And that gives, so we now have to send 2, but the EDC still only send 1. How's that fair? Or the EGS
Yeah, I think you're flipping.
Yeah. The EGSs, right now the EGSs send 1 bill and the EDC
If the
send
EGSs sell these products and services, they have to send a separate bill.
Right, but your way of addressing the discrimination would be to have the EDC send 2.
My preferred way would be for having
I know that's your
one for
preferred way.
everybody. But if you had to do it a different way, the different way to do it was what the commission did in the Columbia case, and say you can't bill for products and services for yourself or for others unless you bill for them. And if you don't, you can't bill for these products and services at all.
Counsel, can you go back one step for me to section 28046? Because I'm still hung up on the fact that that section of the statute refers to billing of all electric services. How are these non-commodity products that you're talking about fit into 28046?
28046 doesn't talk about the.
Oh, I'm sorry.
You're talking about 2807C.
I'm sorry, yes, yeah.
And Section 2807C says that the utility is essentially the default biller. So if subject to the customer's choice to receive a separate bill for their commodity from the EGS, the utility will bill for all electric services on their end, regardless of the provider of those services. And so your question is, how does that require the utility to put these on the bill? I'm not saying that it requires them to put that on the bill. I'm saying that the fairness, that the discrimination provision requires them to put that on the bill. That provision impacts this case because it requires that the utility is the only party that can send 1 bill.
But it's, you're saying also that the services don't necessarily overlap. So let's say the distributor is billing for electric-related services, and you want to bill for roof repairs and carpet cleaning. I don't understand why the distributors should be billing for those non-electric related services. Maybe I'm missing something, and if so, please explain it to me.
Since the beginning of public utility, I mean, I can't tell you when, the public utilities have billed for these types of services on the bill. The commission has regulations that specify how they get billed, that they have to be separately stated on the bill, that service can't be termed.
These types of services.
I'm talking about like furnace repair, warranties, anything. And the utilities have been selling these services to their customers with the convenience of having it on 1 bill since before choice. And so That's the services. I mean, the service that we're talking about here is the billing service, not these individual services.
Except that the statute refers to electric services, not billing services. I mean,
Billing-
it's obviously an unfair or distasteful or it's a competitive disadvantage. The question is whether it's barred by the current statutory law or whether you need to go back to the General Assembly and lobby them to change the law that they passed. Why is it the former, not the latter?
I think because we still have Section 1502, which prohibits the utility from discriminating in the provision of service to anybody, and this is clearly discrimination.
Yeah, but it's the provision of service, which is electric service,
No, it's billing service.
for electric service.
Service.
For
But-
electric service, billing service for electric
And
service.
we're seeking to have billing service provided for us on the same terms and conditions, at the same way that the utility bills for itself.
But they are, because they send one bill and you send one bill.
But they're including things on their bill that they won't include for us. We don't send one bill. No supplier sends its own bill.
For these ancillary non-commodity services, they don't.
Well, for the non-commodity services,
That's what we're
they do,
talking
but for
about.
the service, but for the billing, for service, for EGS service, for the commodity,
Well, of course not, because that's the scheme the General Assembly set up. But right now, the distribution companies send one bill for non-commodity services, and the EGSs send one bill for non-commodity services. How's that
no, the
different?
utility sends one bill for electric distribution service, electric commodity services, and the non-commodity.
Still one
service.
bill.
It is one bill, but it includes our other charges, and they bill for
Because
the.
that's what the General Assembly requires them to do.
Correct, but we believe that, and we suggest here that the anti-discrimination provisions require them to bill for our non-commodity products. and services.
So you want one bill and no bill, as opposed to one and one. You want to go.
Correct.
You want to go, and you say that's okay. I don't know. My math's a little rusty, but 1 to 1 seems equal versus 1 to 0.
If they have the opportunity to include all of those charges on one bill, and we don't, and they're discriminating, they're getting a business advantage from that.
How is that an unreasonable prejudice or disadvantage?
Because customers want a single bill, and the customers are more likely to buy it from the party that provides a single bill.
Electric customers, though, I mean, when you get into this broad category of services, I just don't follow how that should necessarily be required on your electric bill.
Those services are all sold by the utility and are all sold on the premise that they are billed on the electric utility bill. These aren't random services that are being provided to people they're all being provided by the utility, by contractors who work for the utility, and they're all being billed on the utility bill.
Are those services encompassed under Section 102, if you were looking for a definitional provision for that?
I don't think these services would all fall under, they could potentially, and I can't say because the universe is potentially large. So I couldn't say with certainty that all of them would meet that definition, but I think some of them might.
Well, see, that's an important question Justice Mundy asks, because Section 102, I mean, I agree with you, it's not random. I mean, you're not just like selling them Play-Doh. But the question is, under 102, is it in the performance of their duties under this part? You don't have a duty to sell tree clearance. You don't have a duty to sell, these surge protectors. I mean, it's perfectly fine that you do, but these are matters not within the statute. These are matters that are not covered by the current statutory language. Am I wrong?
The non-commodity products and services are not part of the statute. The billing service is, and the billing service has to be provided on a non-discriminatory basis.
But the billing services of what? That's
It's billing service.
well, you're. Yeah.
But it's
That's your point. Your point is we have to read billing service out of context.
I don't think so. I mean, billing service, if they're putting it on the utility bill that's paid for by the ratepayers, and they're billing for these services, it's a utility facility. They can't decide. As I said in the beginning, the utility is a competitor and the utility as the neutral party, because there are lots of competitors that operate on its system, and it can't favor any of them. Like EGS is all competing.
Of course not, but they're what the PUC cares about is not about who's competing for tree clearance. The PUC cares about competition in the sense of an EDC discriminating against billing for a particular EGS by saying, if you pick a green company, we're not going to bill for their services. We're just not going to do it. We're not going to include them on our bill. You green company, green energy company, you're going to have to bill them separately. That's what the PUC cares about. That's what the code cares about. To Justice Weck's point, what possible statutory language could you be pointing to where the General Assembly intended to encompass within this code non-regulated, what you call non-commodity services that the PUC doesn't even care about?
I say Section 1502 would prevent the utility from providing discriminatory service. And as long as it's providing a business advantage, in the Commission's own words, it's providing a business advantage to a bill for these services on that bill, that's discrimination. The Commission already found this in another case, in the Columbia case. And the Commission said it's providing itself an advantage.
Can I follow up to my question about Section 102? As I read that section, it's really, the term service is used in its very broadest and most inclusive sense,
Yes.
which would cover the items that you're seeking to have included on the bills. And there's only two very specific exceptions to service, being ambulance service and the transportation of voting machines. So why wouldn't you rely on 102 to say this is included?
In our brief, we do say 102 is broad. I just can't say that I don't know all the services. I'm sorry, I don't know all the services that are included that are being billed on the bill. I can't sit here today and tell you that it's not ambulance service. I don't think it is, but I don't know what the limitations are, so I can't say. I'm not going to tell you that they're all covered.
Well, it seems to me you're saying there are no limitations. I mean, given some of the hypotheticals I've asked you.
There really, in general, there aren't. But but if we had to limit it to things that were defined as service, that would be fine.
Okay, do you want to wrap up?
Yes, I can wrap up. Just all I would say is there's two provisions. We've touched on both of them. The utilities are, in this case, are the monopoly provider of a monopoly service, which is the billing service, and they're acting discriminatorily in not providing that service to my clients, and that's the essence of our case. Thank you.
Good morning, Your Honors. My name is Tiffany Tran, and I represent the Public Utility Commission in this matter. With me here today is Attorney Devin Ryan, who will be representing intervener First Energy. We'll be sharing our argument. My presentation on behalf of the Commission will be focused on Section 1502 of the Code, the Competition Act, and IGS's argument concerning customer convenience regarding billing. Mr. Ryan, on behalf of First Energy, will be covering First Energy's tariff and its prohibition on billing for EGS's non-commodity products, the administrative and financial costs of reprogramming First Energy's billing system to accommodate EGS's non-commodity products, and First Energy's provision of its own non-commodity products. The Commonwealth Court properly found that the Commission committed no error of law in affirming the Commission's orders finding that First Energy is not engaging in discrimination of service against IGS in violation of the Public Utility Code. Now, first, Your Honors, I'd like to correct counsel for IGS's representations about the Commission's prior decision in Columbia. Counsel for IGS has stated that the Commission found that Columbia could not provide its own non-commodity products and also refused to bill for third parties' non-commodity products. That is not the fact pattern in Columbia. In Columbia, it was a situation where the gas company, the gas utility, was billing for non-commodity products to former affiliates, third parties, but not providing on-bill billing for the non-commodities of other third parties. Therefore, this is a situation where the Commission has found that a utility was offering non-commodity billing for certain third parties, but not to other third parties. That is not the case in the case at bar, where First Energy is billing for its own non-commodity products, but not offering on-bill billing for any third party's non-commodity products.
Counsel, so are you then conceding that because you found in Columbia Gas that that is a discriminatory practice, that this billing service that they identify is subject to the anti-discrimination provisions, and even if it's relating to non-commodity products?
Your Honor, it is only related to the anti-discrimination provisions to the extent that the utility is offering it to certain third parties, but not to others.
But there's some questions you heard up here about the billing service being related to electricity.
Certainly.
You couldn't have reached the result in Columbia Gas unless you read the discriminatory language much broader.
I'm sorry, can you say that?
You couldn't have reached the decision you reached in Columbia Gas unless you reached the decision you reached in Columbia Gas unless you determined that billing services applies not just to electric service but to non-commodity products.
In the Columbia Gas case, it was a gas utility which operates under a different statutory scheme than electric service, which is governed by the Competition Act. And as you know, a number of justices have identified in the questioning of counsel for IGS, the scope of the Competition Act limits, well, let me phrase it this way. Section 1502 describes situations where a public utility as to service makes or grants an unreasonable preference or advantage to any corporation, or disadvantage or prejudice against any corporation. Service under Section 102, as I believe Justice Mundy has indicated, refers to a utility's duties under the Public Utility Code. First Energy and other EDCs, their duties under the Public Utility Code as to EGSs is set forth in the Competition Act under 28046 and 2807C. And the language of those provisions of the Competition Act clearly, as a number of justices again have identified, are limited to electric services related to the electric transmission and distribution system. So these non-commodity products are not within the scope of what was contemplated, and specifically under Section 2807C, the preamble says that subject to the right of an end-use customer to receive separate bills from its electric generation supplier, the EDC may be responsible for billing customers for all electric services. The term non-commodity products does not appear.
Well, but the non-commodity products doesn't appear in the statutes that were at issue in Columbia Gas either.
That is correct, Your Honor, but...
So that's what I'm trying to understand. So clearly Columbia Gas is factually distinguishable.
Yes.
Are you saying that it's also statutorily distinguishable, that the statutes in both cases were materially different?
Yes, Your Honor. Let me pull out the natural gas distribution companies operate under Section 2203, subsection 4, and it does. There is no language in there that limits billing to gas services. But under 28046, which is applicable to EDCs under the Competition Act, there is language in the statute that says it's limited to electric services.
Does that, in your view, defeat President Judge Cone-Jubilier's argument and dissent about the 1502 language? In other words, I guess what I'm saying is, are you telling us that 2807C and Section 102, I suppose, serve to qualify the application of 1502 here?
Yes, Your Honor. Because Section 1502 is a broad prohibition, but again, the service, the duties under the definition of service that the EDCs are required to provide by the General Assembly's own definition only identifies electric services and billing for electric services.
So in other words, so put differently, but for 2807C and 102, 1502 would be a problem for you apropos of Columbia Gas.
Yes, Your Honor, but there's a different statutory language in play, and the General Assembly has put restricting language on the billing obligations. 2807C specifically addresses billing obligations.
Well, let me then, one last follow-up then.
Yes, sir.
If the statutes are different, are you saying that First Energy could do what the utility did in Columbia Gas here, and it would be fine. They could offer on-bill billing for non-commodity services to some EGSs but not others, without violating the statute.
I'm not saying that, Your Honor.
Well, you seem to be saying that because you're saying that this case is factually distinguishable and the statutes are different. What was prohibited in Columbia Gas, what was prohibited in Columbia Gas is not the same statute that we're dealing with here. Well, I'll ask it more directly.
Yes.
Could First Energy, under this statutory scheme, offer on-bill billing for non-commodity services to some EGSs and not others?
It would not. The commission would follow its precedent in Columbia and find that First Energy is discriminating as amongst third parties.
Okay, so what statutory provision gives you that hook? That the scenario I have given you, the Columbia Gas scenario, is what statutory provision would that prohibit?
That would go back to 1502, the general prohibition on discrimination.
Even though you believe that the discrimination only relates to billing of electric services?
More to the point, Your Honor, the commission's view is that discrimination.
I'm not asking you what the commission's view is. I'm asking you what the statutory hook is for the commission's view. What is if the 1502 language only relates to the billing of electric services, how would them billing for non-commodity services for some EGSs but not others violate it?
Because in that situation, the utility would be stepping outside of its service obligations and offering a service to certain parties that it's not offering to other parties, and that would be discriminatory conduct. And the commission, let me put it this way.
Even though it relates not to electric services?
Correct. This is why, in Columbia Gas, the commission also found that this was discriminatory conduct in terms of just offering this option to some third parties and not the third parties. We can leave the idea that we're dealing with a gas company versus an electric company out of it with regard to the non-commodity products, simply because they're still third parties in either case.
So 1502 can provide a basis for discrimination relating to billing services for non-commodity products.
Yes, Your Honor.
Well, that's what their argument is.
But their argument is based on the idea that the utility is billing for its own non-commodity services, not the idea that the utility is billing for certain third parties' non-commodity service and not other third parties' non-commodity services.
So under your argument, or under your understanding, rather, the electrical distribution company can bill for its own services, own ancillary services, and not bill for those services or any services provided by the electric generation companies, as long as they're not treating other electric generation companies differently.
That's correct, Your Honor. And to the extent that that IGS has mentioned that EGSs don't issue their own bills for commodities, I would point out that the preamble of Section 2807C says, subject to the right of an end-use customer to choose to receive separate bills from the electric generation supplier. EGSs are mandated to have the ability to bill for their own commodity and non-commodity charges. They just have, for some reason, apparently chosen not to do so. But if a customer asks, they have that right. And I would like to draw the court's attention to the fact that there's a lot of, as I believe Justice Probson noted, there's a lot of policy issues that, and when they come to addressing fairness of issuing one bill versus one bill or one bill versus three bills, that is something that the commission is concerned about. This is a situation where if we were to take IGS's solution, have all of IGS's non-commodities billed on First Energy's electric bill, that's going to potentially add up to a number of things. The commission does not regulate what these non-commodities are. They could be anything from a smart thermostat to a discount subscription to Netflix. It doesn't have to be limited. Counsel admitted there's no limitation here.
Would it be okay for you to do it on behalf of First Energy?
It would be First Energy billing for its own services and not having to, and Mr. Ryan will address this further, you would be placing the burden of billing for EGS's non-commodities and collecting for those non-commodities on First Energy and ultimately First Energy's ratepayers.
I appreciate your policy position, but if we're looking at this from a statutory construction standard, I really have a hard time getting by no public utility shall as to service make or grant any unreasonable preference or advantage to any person, corporation, or municipal corporation, blah, 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 blah. It seems to me that your carve-out distinguishing the Columbia Gas case doesn't stand scrutiny under the very verbiage of the statute.
Wait, Your Honor, this, in section, you said section 1502, correct?
1502.
Yeah, section 1502 is, there is no language in section 1502 that says, as between the utility and a third party. It's basically saying, you know, the utility can't discriminate by giving an advantage to some, but not to others.
Because the utility's paying, it's incurring its own cost for its own billing.
Of the any person, corporation, there's not a carve out here for First Energy.
There's, oh, sorry, I'm sorry.
Any means any. That's a very inclusive term.
I respectfully disagree, Your Honor. There is no case law in that has ever come out where any court has interpreted Section 1502 as meaning that a public utility cannot treat itself differently than it can a third party. This,
Well, your answers to my question about Columbia Gas
yes, Your Honor.
seem to be limiting 1502 to sort of exclude the EDC. It requires a third party being benefit over another third party.
Correct, Your Honor. And in
But to Justice Mundy's point, the language doesn't say that. The language is any, it doesn't say any EGS. It says any company.
But it says to that company.
Right, which could be, I'm going to give myself a benefit.
I respectfully, Your Honor, I don't read it that way, and the Commonwealth Court did not read it.
Oh, I know they
that way.
didn't. I'm just saying, why can't you read it that way? Why can't, when it says any, why couldn't we interpret the General Assembly as saying
Because then it
any
would-
means any?
it
If
would
you give
lead-
yourself a benefit over another company, then that's any company.
Well, I'm sorry.
No, you go ahead. I'm dying to answer his question, but I'll wait.
Because, Your Honor, that would lead to the absurd result that we have today, where we have the EGS, and this is not just IGS. This is the universe of EGSs and third parties that First Energy would have to, expend millions of dollars to reprogram its billing system
No,
to
or
accommodate
separately build them.
or separately bill them. But I'll finish my train of thought. That the First Energy would have to expend all of these efforts, administrative, financial, collections, and billing, to bill for somebody else's products when it's not required to under any provision of the Public Utility Code.
Where when they bill for their own products, they're incurring the cost of billing, the computerization, the whatever costs are contained in their own billing. They're assuming those costs as opposed to assuming the costs to do it for other companies, and the question being, are they doing it for some companies and not others?
Yes, Your Honor. Your Honor is on point, and I would like to add to that. The more of these services you add onto First Energy's bill, the more you're going to have complaints from customers contacting First Energy about the EGS's commodity products, complaining to First Energy about these products that First Energy isn't offering. And you're also going to end up with a situation where these customers are going to be contacting the Commission, filing complaints about these non-commodity services which are not provided by First Energy. And all of this adds up to expense and time and resources of First Energy and the Commission, which is ultimately passed on to ratepayers. And that's not what our position is. That's not what the General Assembly ever intended. It only ever intended to require public utility, as under the Competition Act, EDCs, to bill for electric services, not for non-commodity products offered by third parties such as EGSs.
Okay, are there any other questions? Now that she's agreed with me? Or I've agreed with her, I guess. Do you want to wrap up, Ms. Tran?
Thank you, Your Honor, and respectfully, I just would like to ask that this court affirm the Commonwealth Court's decision in this matter, and thank you very much for your time.
Thank you. from Mr. Ryan.
May it please the court, my name is Devin Ryan from the law firm Post & Shell. I'm the attorney representing Intervenor First Energy Pennsylvania Electric Company here today. As Ms. Tran had noted before, I was here to provide some additional context to the company's arrangement with HomeServe, as well as the additional programs that the company administers to provide these non-commodity products and services, as they've been termed, to its customers, as well as the provisions of the company's tariff that control and prohibit the company from billing these services that IGS wants to have placed on the company's bills, as well as the administrative and financial cost that would be incurred by the company if it were to have to implement the relief that has been requested by the petitioners here today. So,
You can also talk about the relief, that the cost and expense if you had to separately bill?
I could, Your Honor. I don't have specifics as to that because we didn't have a factional record.
That would be another way
developed.
to address to
Certainly, Your Honor. But I think that your example there, you're running through with petitioner's counsel was very apt. Where you're saying, you know, if under one way to address their concerns is to have 3 bills issued in total, 2 by the electric distribution company, 1 by the EGS, whereas their preferred relief is 1 bill entirely by the EDC, 0 bills by the EGS. And I think that that very plainly sets forth sort of the disparity and I would think the actual competitive disadvantage that would result from granting the requested relief here today. But I do not have specific figures as to how much that would actually cost the company in order to issue those separate bills. So these types of services that the company offers to its customers are laid out in Company's Exhibit 1 that was presented in the proceeding below. And to petitioner's counsel point where they said, well, we can't really do a one-to-one comparing all those various services. I won't go through all of them here today, but there was particular services that were called out in the Commonwealth Court and before the PUC involving HomeServe, which is a third party that the company has contracted to administer First Energy Zone programs. So to be clear here today, and I don't believe it's been raised as an issue on appeal, but First Energy does not allow any third party, affiliated or unaffiliated, to bill for its non-commodity products and services on First Energy's bills. What we're concerned with here today are solely programs, costs that the company administers itself and bills to its customers.
Why isn't President Judge Cone-Jubileer correct that you're violating 1502 by giving yourself an advantage and denying it to First Interstate and the similar EDCs?
It's a great question, Justice Weck, and I respectfully disagree with the dissent below. 1502 does have additional language besides the very first part that we've been focusing on here today, which is shall not, as to service, grant an unreasonable advantage to any person, corporation, etc. It then says that you should not subject any person or corporation to an unfair prejudice or disadvantage. It then goes on to say that nothing in here prohibits you from creating reasonable classifications of service. And how that has been traditionally done is through PUC-approved tariffs. The EDCs charge residential customers different rates, have different service provisions applicable to residential customers than they do to small commercial or large industrial customers. Here, we have an entire tariff approved by the Commission, the Supplier Coordination Tariff, that applies to EGSs. They are their own classification of service. EGSs are different from electric distribution companies. So if 1502 permits utilities to have reasonable classifications of service established, then they are permitted to treat themselves differently from EGSs. And if you go into that supplier coordination tariff, which has been subject to review and approval by the Commission, it expressly states that the utility is not going to purchase receivables attached to any other products and services besides basic electric service. And so that's consistent with Section 2807C, which we have been delving in here today, which is that the utility may be responsible for purchasing or for billing electric services. It says nothing about any other non-electric services. So as far as the administrative and financial costs associated with implementing the request for relief, I mean, we're 5 years now past when main briefs were submitted in the case below, before the commission, but First Energy has no billing framework to accommodate what they are asking for. We have a billing framework in place to bill for our own products and services. The IT changes that would be required here would be wholesale. It would take a 2 to 3 year period at an estimated cost of at least $3 million. And again, that was 5 years ago. It's reasonable to assume with inflation that that cost is much different here today. We'd also need to make widespread process changes related to how our purchase of receivables program works. Now, that's the program under which the First Energy buys the right to collect the charges for their commodity products and services. Well, now how do we address that for non-commodity products and services? We would have to establish new payment procedures. We'd have to address how uncollectible expenses, so when customers don't pay for those charges, how do we deal with that? How is the bill presented? How do we communicate with customers, all these issues? Counsel for the commission had brought up, what if a customer calls in to First Energy and says, I have a problem with this non-commodity products and service that is on my bill. Can you tell me what is going on there? First Energy would have no information
What
about
happens
it.
if they make that call now under the current arrangement with respect to electrical services that are billed on your bill on behalf of an EJS?
So First Energy's customer service representatives, to the extent that they can answer it fully, will do so during that call. If they need to refer it out to, and again, most of these programs are administered directly by the company. They do contract with HomeServe, who is another entity for certain of the programs. If the customer service reps cannot answer that, then they would then direct the customer over to HomeServe. But the advantage there, Your Honor, is that First Energy knows who to go to. And if in a situation where a customer calls in and has a problem with an EGS's product and service, the best that we can do is direct them then to the EGS. We don't know if there is then another contractor behind that EGS that they have to go to speak to resolve their issue.
Okay. Counsel, I guess I'm trying to get to the heart of this discrimination concept. You're required to obviously bill for electric services. And you have to do that and encompass the EGSs that are involved. Okay, so you do that. You've also devised your system to encompass the non-commodity services that your client provides, which came at an additional cost in order to do that. Is that correct?
Correct, Your Honor.
Okay, so I'm trying to understand why it's discriminatory not to take on the additional cost of designing your system to accommodate all of the EGSs in that regard. I mean, obviously, if they, not obviously, but I suppose another alternative is if they'd like you to do billing for the non-commodity services, they could pay you to design your system so that those non-commodity services would also be billed on the one bill.
Absolutely, Your Honor. But I think one point of disagreement with me sort of putting out these figures of the $3 million is that IGS and the rest of the petitioners challenged that on the proceeding below.
It doesn't matter.
And I would, if in that situation, if we were forced to then take on those additional costs in order to facilitate the billing of it, you bet you that we're going to be billing them in order to recover those costs.
Well, you'd have to. Otherwise, your clients would be bearing those costs.
Absolutely, Your Honor.
Your customers would be bearing those costs. So in order to not discriminate against your customers, you would have to bill them for the new services that you're providing on their behalf.
Yes, Your Honor. And we'd have to make sure that the rate that was put in place in order to recover those costs was properly designed in order to capture all of it. And
it's unregulated.
Exactly, Your Honor.
You have to put it in a tariff, and the PUC doesn't approve. This is where I struggle with this because the PUC doesn't regulate these products. Period.
Right, Your Honor. And so we'd have this a bit of a abnormal rate or charge by utility to recover costs associated with an IT upgrade to facilitate the billing of products and services that are not regulated by the commission.
That's why it's not a competition issue. It's not a discriminatory practice in that regard. You've designed your system, paid for it separately in order to accommodate these non-commodity charges. You could do the same for them, but they would have to pay you for it.
Right, Your Honor. And you know, it is a very strange scenario where,
Doing something else. You would be
Right.
a billing service for non-commodity services.
correct, Your Honor. Yeah, I think there's a distinction we need to draw here between Competition Act, where you're regulating the competition regarding the provision of electric services, versus competition that exists outside of the purview of the commission.
You could amend your tariff to deal with their claim by saying, we will provide it to third party, we will provide this service to third parties, but we're going to charge them $200 billion for the service. And if the PUC passes that tariff, which they'd have no reason not to pass it, because they don't regulate it, you'd be fine, because there's no way they're going to pay $200 billion for you to be a billing coordinator.
I wouldn't
Yeah.
do that.
I don't know what the PUC could do about it. It's an unregulated, you're giving equal access to all of them, you're satisfying Columbia Gas, you're not discriminating. I don't know what the PUC could do about it.
And strangely enough, Your Honor, if it wasn't a charge for a regulated service, I'm not even sure why it would need to be put in the tariff. And we could just invoice them and say, this is how much you have to pay for it.
Mr. Ryan, has there been any acknowledgement by the EGS Council that they would be willing to pay for these services?
They have indicated that, Your Honor, but I think it ties back to sort of how much they're willing to go and pay for that. You know, again, there was a point of disagreement about us saying it would be $3 million. They thought it would be substantially less. I don't know if it truly was $3 million, they'd be willing to bear it. And then there's also the question of who all do you recover it from? Is it the entire EGS base, or is it only from the ones that are also providing these non-commodity products and services, or is it also the ones that are only seeking to have those charges put on the EDC's bill? And the more you narrow that down, the more costs are going to be recovered from a fewer number of EGSs, and then increases the likelihood that maybe they don't want to have to bear all those costs.
But doesn't that dilute your argument in terms of, gee, you can't do it, it's too expensive?
I think, Your Honor, that with the expense, there's sort of this risk of, if we have to undertake that IT upgrade, are we ultimately going to be able to recover those costs fully from the EGSs? And if we fall short of that, then those costs will be passed on to our ratepayers. And
again, no regulatory oversight for that process?
there would be some, to some extent, Your Honors, for whenever we file a base rate case for things that are non-jurisdictional costs and revenues, we have to back that out. So this would fall sort of within that bucket. But again, you'd have to vet and make sure that we are actually capturing every last penny.
Okay, any other questions for Mr. Ryan? Thank you. Those were outstanding arguments. Thank you, all three of you.
Great, thank you.
And you on the briefs and co-counsel, thank you.
Thank you, Your Honor.
The court is going to take a brief lunch break. Let's see, it's 10 after 12. We'll resume at 1 o'clock.
Court is in recess until 1 o'clock. Attorney Rice and Bain.
In May 2021, Appellant was arrested for DUI, and he was charged on that offense in July 2021. Later, that same month of July, Appellant was arrested for a second DUI offense. However, he was not charged on the second offense until March of the next year. Prior to being charged on the second offense, Appellant applied for and was accepted into an ARD program for his first offense. In his application, Appellant attested accurately that he had not previously participated in ARD and that he had no pending misdemeanor or felony criminal charges. When the Commonwealth subsequently learned that Appellant was charged for a second DUI offense on March 22nd, 2022, during the time he was in the ARD program, the Commonwealth filed a motion to revoke his ARD. The trial court granted the motion, and Appellant was subsequently convicted at trial for his first DUI. Appellant appealed, arguing there was no basis to revoke his ARD because he answered all of the questions on the ARD application truthfully, and he did not violate the terms and conditions of ARD while he was in the program. The Superior Court affirmed, concluding that Appellant violated the spirit of the ARD program when he failed to voluntarily disclose on his ARD application his arrest for a second DUI, despite the fact that no charges had been filed. We granted review to consider whether a trial court may revoke ARD based on a violation of the spirit of the program, even though a participant answered all of the questions on the ARD application truthfully and did not violate any condition of ARD or any condition of parole. Please proceed.
Good morning, and I should say good afternoon, and may it please the court. My name is Steve Rice. I represent the appellant, Benjamin Jenkins. I'd like to start with a Harvard on the Susquehanna approach. And I have two kids in the room, so I really want to try and get something simple out that I think they'll understand.
And that we'll understand.
We're hoping, but I know it's going to get tough up here. So we have a form that doesn't ask about arrest. It's striking that it's now been 2 years of litigation. There still isn't a change to the form. If you want to ask about prior arrests, and I'm not just talking about Chapter 18 prior arrests, change the form. For that matter, and there are lessons in the case law, both from the Pennsylvania Supreme Court and from the Pennsylvania Superior Court. If you want to ask for a general criminal history statement, I'm not saying I won't challenge it on a later day, but if you want to ask that and you want to expect disclosure, okay. If you want to go further than that and say, we want to know about any prior bad act you've ever done, you can ask the question. I'm not saying I won't challenge it. Then maybe argue that someone lied. But who among us wouldn't have something to disclose? I submit courts and district attorneys' offices make judgments. And they make those judgments for a reason. And in this particular instance, and if you look at the form itself, it says in consideration for admission to the program. There's been some conflation, I submit, between conditions for admission and conditions of participation. There is no mistaking in this instance, we are talking about conditions of admission, otherwise known, I would submit, as eligibility requirements. So if you want to ask about something, if you want to ask about someone who might strike the vehicle of a Supreme Court justice on her way to a spa, okay. Okay. But ask the question. That's all we're saying. And we're not even saying that it's unreasonable, particularly in this instance dealing with arrests. But
on this form, the ARD form, there, am I correct, there was no provision requiring or invoking a duty to report or change circumstances, nothing like that.
So I'm going to answer that question, but I'd like to answer another because I think you may be driving at a different point.
Oh, okay.
So I don't believe there's anything on the form that does say that.
I didn't see it.
But if you go to the published administrative orders that are on the website, Adams County's website, I believe you will find published there old conditions. I think they have the same thing on a new form, but old conditions. And this is very similar in a lot of the jurisdictions that I practice, where they ask about reporting contact with law enforcement. I submit here, there was never an allegation of impropriety there. So if someone does catch a charge based on old conduct before they were an ARD, I think the way that condition reads, it doesn't have a temporal limitation.
Okay.
I can't give you the rule number, but I'm pretty sure that there is something in there, and I'm quite sure in this instance that was never alleged as a violation.
Is that defense attorney lingo, what did you say, catch a charge?
Oh, yeah, I was trying to keep it, Harvard of the Susquehanna, but yes, report any contact with law enforcement, arrests. Different counties are using different language. But I would submit that most of the places we go, there's something like that. So if someone's coming in like, hey, I caught a new charge, do I have to tell my parole officer, my probation officer? I'm often not familiar with the precise language of every condition. But we're normally saying, you might want to check those conditions because there probably is something in there.
But that would be a
about
condition. That would be a condition relating to staying in the program.
Correct. That would be a condition of participation, Your Honor. So the spirit issue was presented as the first issue by this court, but I submit much like the first argument that was presented here. This is about either statutory interpretation of rules, and yes, now within the past couple of years, we have rules of construction for this court, substantially similar as rules of statutory construction. And we have unambiguous language here. It asks about what had happened before. I submit there's no other place the court needs to go, and if it thought it did need to go there, we submit the Rosario case resolves it completely. I'm aware that you, Justice Brobson, and you, Justice Mundy, participated in a very well-developed, passionate, dissenting opinion in that case. And I know that there were other justices that were in the majority, and I know that Justice McCaffrey participated in the Simmons case, very similar, a forerunner to that case. And I believe there was a strong concurring opinion in that case that essentially was on all fours with the court's case in Rosario. But in Rosario, we were dealing with a situation where there was a temporal limitation, talking about violations occurring during probation. I think the word may have been while. And here, it's probably better language. During the time that someone's in the program. I think it's something like that. If you look at Rule 318. I'm sure it's not lost in this court, but I'll say it because I wasn't sure about it in coming here, that there is a Supreme Court case, Low-Miller, and I can give Your Honors the citation if I need to, that says you got to look at rules in statutes together too. It's not just statutes. It's not just rules. Rules in statutes, that rule of in para materia, if I'm saying it right, applies for those as well. I submit there is no material distinction between the two cases as it relates to when the violation needs to occur. Now, because of the way Your Honors had crafted the questions, there's a place I didn't go, but I thought, I might get something thrown at me, so I'd at least like to volunteer something here that I think might be relevant to the court's consideration. Because there is this question about, well, what if there's something that happens outside of the time that someone's in the program? So we now have a number of cases in this jurisdiction, certainly others, where there have been allegations that someone has been deceptive or fraudulent or something to that effect. And we have seen instances where it is based on something that happened before someone went into the program. What was striking to me is what I didn't see in these cases. Not a single citation that I can recall to Title 42, Section 5505, dealing with the court's ability to modify or rescind court orders within 30 days. Now, if you look at the times that expired in some of these cases, I submit that the case law, while they might not have mentioned it, just might comport with that law. So if we're dealing with a situation where something is discovered the day after, incidentally, the court had cited to the Gano case, where in dicta, I guess the day after, the judge was like, wait a second, I saw something in the papers. No, this guy doesn't belong there. It was never raised as an issue. It was never raised as an issue by the defendant. That's important here, and I'm not conceding the point for a future day. But I would submit in that instance, if you look at 5505, it wouldn't offend that because it happened within 30 days. Now, if we're looking for instances where someone did do something fraudulent and you did find out about it 2 months later, 3 months later, for that matter, a year later, I'm not sure what limitation there is other than acting expeditiously. Whenever you're dealing with an instance of fraud, and of course we know about clerical errors where things can happen sometime down the road where there are changes well beyond that 30-day period of time. I submit to the court, this case is very straightforward. We're dealing with clear and unambiguous language in the statute. We're dealing with clear and unambiguous language in the rules, state and local. Incidentally, there was reference to local practice. If you look at Rule 103 of the Rules of Judicial Administration, that's a local rule. It better be submitted and it better be published if you want to come into court complaining about it. I submit that wasn't done here. I submit that there was no deception. I submit that nothing wrong happened. And my hope is, and this is what I had argued in the brief, that discussions like this, which relate very much to policy, just like if you're in front of the legislature, yes, of course, they should inform judgments about what's going to be in a form, about what's going to be in an application. Those are discussions that should be had, and it's a worthy discussion about whether asking about prior arrests for DUI or other things for that matter should be in the form. One of the interesting things about this website that I referred to, the court talks about how it solicited input from the Bar Association and from some of the committees. I'd love to be on that committee about what should ultimately be in that form before a court adopts it.
Counsel, there's an application process. We can get it to you if you really want to apply for it.
Go on our website.
If I get it from you, Justice McCaffrey, I'm on it. Yeah, I'm there. I'm there.
Can I ask you?
Yes.
You're getting off relatively easy. This is so, but
Oh, the day is young.
It's coming.
Okay, still
It's
got
coming.
time. I'm gonna give my colleagues some time to pause. If there was a colloquy, and the judge asked the question, right? Before you go, we're going to accept, you've applied for ARD, you've done the questionnaire, the judge still has some level of discretion. And the judge had asked, hey, just before I put you into this thing, anything else you think you should disclose? Is there any prior, did you get pulled over, or is there a possibility you might be cited for something? Would we be in a different situation?
I think we would, and not because I'm answering the question, because this court has answered that question. In the Booz case, it was pretty similar. I don't think there was an application like what we have here. I think there had been a letter that had gone out from the district attorney's office, and I think there was at least one, perhaps two, oral recitations about some of the conditions for admission. I'm not saying it needs to be in this application or any application, but there certainly has to be notice. And in that instance, I think it's significant that it wasn't just oral.
But counsel,
There was also written notice that was in there.
in Booz, the defendant lied. He had 2 prior convictions. That is
question.
completely distinguishable from this case in which there are no convictions or even prosecutions at this point in time.
No question. What I'm saying is, and maybe I was pairing something I shouldn't have been, I thought I was supposed to assume the facts of my case and that we're in court and that the judge had said that. And if that had happened, I'm an officer of the court. Whoa.
Yeah, and you agree that the district attorney also has a discretionary aspect to letting people in, and
Absolutely.
they can ask almost virtually any question they want to ask. The problem here is, and this is why you're here, is they didn't ask these questions. Neither the trial court asked it, neither the forum asked it, nor did the DA ask it.
And nobody lied. He didn't lie.
Thank you. Let's just say, I'm not so sure that was the discussion in a lot of the documents leading up to this point. And as this court, I'm sure, is aware, I took some shots on that. Okay. Yeah, no deception in this instance.
Well, I kind of tend to disagree. I think when, surprise, I think when you see a form that says pending criminal charges, that you as an attorney, you as an attorney before this bar, you have an inkling of what they're looking for, and it's pretty brave of you to not seek clarification, I would say. And I understand legal obligation, but I think it's cutting it close to the line.
Fair enough, but I come here with pride, Your Honor. We as lawyers, particularly we as criminal defense lawyers, are challenged a lot of the time
Well, let me
with
ask you
clients who are asking.
Let me ask you a different way, because I've been on this court now for
Certainly.
14 months, and you're kind of touching on issues that I've kind of seen. How many counties do you practice in?
Regularly, 3 or 4.
How many different ARD applications have you seen? Because I practiced law for quite some time, and I can tell you from county to county, it's different. The application process is different. We ran into this in a case I wrote on the Superior Court, which was Chichkin, which was the ARD situation that we've taken up on Shiflet. There seems to be this kind of...
I was going to ask about that one, but I didn't think it'd be
Don't
a
ask
good
about it
time.
now. We'll tell you later. But my issue is, and I thought about this a lot, is I think what you're really advocating here, or what you're really talking about, is a standardized application of ARD for an admission-based criteria into the program that's applicable across 67 counties. The ARD, I mean, I understand the idea of giving a DA discretion to allow people into a program, but that leads to all kinds of questions as a Superior Court judge on what's an abuse of discretion, what's not an abuse of discretion, whether or not it was abused. If we have an admission-based criteria for an application process, wouldn't that alleviate these concerns? And we also ran into it in the context of a DA in Lancaster County creating his own diversion program that no other county kind of knew about, and what the funds were for and how the funds were allocated. I mean, look no further than what's happening in Philadelphia. We have 80% of gun arrests that aren't prosecuted anymore. So I'm wondering about whether or not this is better dealt with in a rules-based criteria application.
So uniformity, particularly for attorneys that practice in multiple counties, would be extraordinarily helpful. I'll sign that petition. I just don't know that I have the authority.
Let me go beyond that, though. I think we would all agree that's a great idea, and we ought to pursue that through our rules, because if a rule is uniform, it's much easier for attorneys who practice in more than one county. But my concern goes beyond that, and that is, can we, should we, is it appropriate to ask about arrests, not charges, not convictions, but arrests, when an arrest can be meaningless? An arrest may not result in a prosecution.
Could result in disproportionate minority contact and bias.
And as this court knows, because it comes from a rule of this court, Rule 519 says 5 days. 5 days. This was months and months that went by. And if I may address Justice Mundy's point, because I don't just want your vote, I'd like your respect here. So imagine someone comes to me and says that they molested their younger sister whenever they were young. No one knows about it. It's never been reported. Am I supposed to espouse that this thing is a confessional, anything that might disqualify you in the eyes of the court or the district attorney's office? Am I now supposed to be the volunteer of that information, or am I supposed to help that person interpret what's being requested?
I think my point was more towards the fact that, as I understand the record, and correct me if I'm wrong, that your client had been arrested for another DUI offense, had been taken to a police facility, and had his blood drawn for a DUI offense.
So
And was arrested.
It's not in the record, but I will be direct in answering your question. There's no question I had knowledge that he had been arrested. And just like I would anyone else, I talk about what it is that a person's confronted by in an application. And I said, it's not asking. Of course, you have a discussion like, well, look, if for some reason something happens, this could happen. There'll be arguments. How's it going to play out? And if you were to say to me, for every client, is a DA, if they find out about this, are they going to not let someone in? Can I tell you how many times I'd have issues? Because there's things that come up in conversations, confidential conversations. I mean, what am I going to be doing here? Turning my clients in? I'm trying to do what I'm charged to do under the Constitution, but I need the help of the court to do it, right?
Do you want to talk any more about the booze case? Because I think any DUI case should refer to the booze case.
So my recall of that case is we had someone.
She's fooling around here.
Oh,
Get it, booze?
Well,
See?
it is relevant. It is relevant.
more than one person with a family say, sometimes you're not listening.
All
Yeah.
right. Well, we know that concerned prior convictions, and this is prior arrests. And there is a big difference between a conviction and an arrest, and we've recognized that. Our court certainly recognizes that.
And if they include that in the application, I haven't said I wouldn't challenge it. I'm saying
They did.
ask it first. That's how we lawyers behave, so we are prevented from people in power exercising arbitrary rule.
You're taking a very specific, it's like when you represent a client in a deposition. Only answer the question they're asking you. That's the approach that you're taking. Don't think about what they're trying to get to. Don't short circuit the process. It's their responsibility to ask the questions, answer what they ask you, and your client did nothing wrong.
You're asking about all instances. I will speak to this one. In my view, and in my heart, I believe that question was answered honestly. In my view, if the court thought it was important enough to make it a disqualifier, the court would have and certainly should have said so. And if there was some type of practice, and I will tell you as I stand here, I can't think of a single case that I've been involved in identical to this one. I'm not going to say it hasn't happened, but you can bet when things like that happen, particularly if someone starts calling someone dishonest, that's when some attorneys start doing things pro bono.
Yeah, and you were hired by the defendant. You weren't hired by the DA's office. You weren't hired to
Absolutely.
assist the prosecution.
Absolutely.
And how does one, maybe this question is better aimed at the Commonwealth, but how does one truly know if he is violating the spirit of a rule? I mean, that's where
That's part of the challenge
that's where
here.
the Superior Court went here, and I just don't know what kind of precedent that would give us. How would we know that?
Just if we consider history, if the test had to be, would someone in power want to know it? How scary a world would that be? Whoa. I don't want to live in that one. None of us do.
Okay, any other questions?
My only question is, did your kids enjoy this case as much as they enjoyed the electric billing case?
Which one are your children?
My daughter, Sarah Rice, and my son, Gabriel Rice. Sarah wants to go to law school.
I was going to ask if you had any future lawyers in the family. Good.
Thank you.
Good luck to you both.
didn't discourage her.
Utility rate review law.
Thank you. Mr. Bay, for the Commonwealth?
Thank you, Your Honor. Good afternoon.
You'll talk to me later about the spirit of the rule, right?
I look forward immensely to that. Ultimately, ARD is a diversionary program meant to rehab, to help keep people out who have generally a single isolated criminal incident which does not harm society severely.
And it's a successful program.
Very much so. I don't know if you recall, but I was here singing its praises a few months back. And I will continue to do so. Here, though, specifically with regard to the facts of what we're dealing with here, I acknowledge that as a technical matter, the defendant did not perjure himself essentially when he
It's
signed.
all about technicalities. This is a crime. This is a criminal case.
And I understand that.
Did not perjure himself, technically or otherwise.
Yes, as I just said, yes. The issue I would take with it is that he was arrested and he was taken to the hospital. He had his blood drawn. And candidly, when I was driving here, a police officer had his lights up behind me. Fortunately, it didn't stop me, but it's something that sticks out in your head. And more to that, it's clearly he knew that this was, he knew it was happening. He was arrested. He knew that this statement here, that while he made it, when he was entered into that program, it's true, but he knew probably within a few months it was not going to be true.
Why didn't you?
That arrests can sometimes not result in charges.
Is that possible? Yes. And if I was informed of that, I would immediately look into it. The problem here is, yes, there was a delay. Unfortunately, the 5-day rule, it's given the evolving case law and what we have to do with blood, it's impossible.
So, just for the record, your office is the one that granted the ARD, yet your office is also the office that knew that he had been arrested and still chose not to bring charges, no?
No, sir.
Different county?
No, it is our office. It's the district attorney's office. Nobody, to my knowledge, in the district attorney's office knew that he had that second arrest. We were not, if you want to impute the knowledge of every officer and trooper onto us, then the answer there would be yes.
So you stand before us, are you arguing that this is a booze case in which he misrepresented or actually lied, or are you saying this is a failure to comply with the conditions of ARD?
I can't, going back to what I said before, I don't think I can put this within the confines of booze. I think that was an actual lie, as I believe Your Honor did.
So this is a failure to comply, and if so, tell me, wherein, what is it, 3807A2 small 2, the only condition is if you're charged with or commit an offense under 18 pursuits. This is not that. So where is the failure to comply with pursuant to that statute, which specifically lays out the requirements for a violation or for a failure to comply?
It's not there.
So then why are we here?
We are here.
Because we don't like the judge's decision?
No, I've not appealed anything.
Yeah, but I'm trying to find out legally, why are we here?
We are here legally because he signed off on the form knowing that, or at least not letting the court know that likely this was going to be untruthful.
That's not
in
his
the future.
obligation. Under what precedent is that his obligation? I mean, you know better than we do that there are all kinds of arrests that don't result in charges, and that he wasn't charged at the time, let alone convicted.
Correct.
So how could we possibly affirm a published opinion of the Superior Court that says a spirit of the law kicks in here rather than the text?
In this matter, again, it goes back to what I initially said, that ARD is a rehabilitation program. It's a diversionary program, and part of that, I think we should require candor from criminal defendants.
That's not what the statute reads. So why should we impose a condition that the General Assembly did not require?
Again, it would go back to knowing that the terms of the application process that you are swearing to and validly doing so at that time will be changing and not letting the court know.
Why, the answer to the question of why we are here is the Commonwealth moved to revoke his ARD.
We did, yes.
And the trial court granted it.
Yes.
And the Superior Court affirmed it.
Yes.
And that's why we're here. And now you are in, enviable or not, the position of having to defend a decision that is extra statutory.
In that sense, yes.
Any sense?
Yeah.
Why don't you just change your form? Why don't you just ask, have you been arrested since your, initial DUI?
Or were you arrested? At the time you were in ARD, have you been arrested but not yet charged for a DUI?
The form, if I had complete control over how to change forms, yes, it would probably already be changed, include in the block, paragraph that I'm sure that all of the justices have looked at, it would say arrests in there as well. Maybe depending on how this court rules, that will change.
Whose form is it?
What's that?
Whose form is it?
So I always took it as a court form.
You don't dispute that you're not the DA.
I'm not.
You're not disputing that the elected DA of Adams County could prepare his own form so long as it didn't violate the statute.
Probably. The way that functionally this worked was, this was in place, I've been with the office 15 years, it was in place before that. There were some modifications that were made.
That's passive voice.
I helped make modifications following Chichkin, and that was the last time it was amended. All modifications were run by the Common Pleas Court. My apologies there. They approved the modifications before anything was changed and provided to any criminal defendants. Does that answer the question there?
Well, the point is, if I could change the form, the fact of the matter is the district attorney has the power to, first of all, change the form if they want to, but the district attorney also has the power to simply ask the question.
Or not offer ARD.
Or not offer ARD, or the Common Pleas Court could ask the question at the colloquy, right?
Certainly, yes.
Yeah, so there is power.
Obviously, had we known that he was arrested, we would not be at this position. No one would have moved for his admission into ARD.
So it's fair to say that if you had known he'd been arrested, that individual doesn't enjoy a presumption of innocence.
No, what I'd say is he was not a good candidate for ARD. And
why so? If there's still, just on the arrest alone, there's a presumption of innocence until he's proven guilty. So you're saying that we're going to vacate or obliterate a presumption based upon an arrest without an official form of prosecution.
So I'm going to ask you to clarify the question. I want to make sure I understand exactly what you're asking.
The question is, so you're saying that an assistant DA or the DA can refuse entry into an ARD program based upon a potential question of, have you ever been arrested? And if that answer were yes, that DA has to presume that there's no presumption of innocence, that the arrest is indicative of guilt, and that he's being or she's being denied entry into a rehabilitative program, despite the fact that in this particular case, none of the above was required or requested.
I would not agree with the way you phrased the question as broadly as you did. Frankly, we have 10-year look-back periods. Somebody could be convicted more than 10 years before.
But that's in the statute, no convictions. We know that.
Sure. But what I think you're asking there is, there's a difference between, say, you got a summary harassment and he robbed a bank. Any time that there's a pending charge, I'm going to take a look at it. and
He's asking you about arrest, not charge. There's a difference.
anytime that there is an arrest and I know about it, I'm going to take a look at it. It could be nothing. If it's nothing,
But the point was, by not having at least the information and the fact that, you were denied the opportunity to potentially get information that would have swayed the district attorney's decision. Not necessarily whether they were guilty or innocent, but police officer report, something like that. There could be something else that would have made this person not amenable to ARD. And you're here because the DA's office feels like they were deprived of that opportunity by some alleged misrepresentation.
again, I wouldn't use that term misrepresentation. I'm not saying that it was.
You're upset because you guys didn't know about the arrest.
Yes.
But you do you understand that were we to affirm this published opinion of the Superior Court, it would be setting a precedent of affirmative obligation on criminal defendants to volunteer information to their detriment. It would have wouldn't that be a breathtaking gesture by this court, not necessarily in a good way?
In this particular instance, with regard to specifically what we're dealing with here, candidly, I've never seen this situation come up in my years with the office. This is a bit of an anomaly. As far as the affirming the Superior Court, it being done on any grounds, whether or not I think what they were trying to do there was, whether it was artful or not, was try to say that this statement that he made, while truthful at the time, he should have known, or at least brought to the attention to either the court or the DA's office, that this statement here was going to be incorrect, or likely would be incorrect. You guys should look into it, make sure you know what's going on, make sure you think I'm a good candidate for it.
So you're reading into it a duty of candor and a continuing duty to disclose or, report that's not in the letter of the.
Yes, to some degree. And the only reason, ultimately, say for taking it out of ARD context, if I make an error in a guideline form, his PRS should be a 3 when it's a 2, I make an offer, that's on me. It is what it is. He has no duty whatsoever. That is completely my fault. When someone's applying for a diversionary program, that's the only time I'm saying that they do have that duty of candor.
As it's a privilege.
Exactly. And it's a diversionary program meant to rehabilitate.
Do you want to give it one more shot on us accepting the spirit of the ARD program argument that was in Judge Stevens' opinion?
That was just it.
I'm sorry.
I think that was just it.
I'm going to give him a shot.
I think I've tried a few times. I'm not sure I've swayed any.
Well, I'm giving you another try.
Like I said, ultimately, the thrust of our argument is that while when he did sign that, the form, it was truthful in a diversionary context setting, if he knows or has reason to know that's going to change in the near future, that he was just arrested for DUI, taken in for blood, he should have a duty to let us know, let the court know, and so we should be able to investigate that before.
Based on what law?
Based upon, I suppose, yes.
So let's make believe you're from Philadelphia, as I am. Now let's make believe that the majority of the people who get stopped in Philadelphia are black and brown people.
Okay.
And let's make believe that when they're stopped and they're arrested, no charges happen, but they finally have an opportunity to receive ARD because a DUI happens. It's your position that it's incumbent and pertinent that that individual share that he or she had been stopped and arrested by the police, despite the fact that there's no prosecution as a result of biasness and prejudice in the system. So again, it may apply well, but I'm thinking, how's it going to apply when I go home?
In this, ultimately, that's,
We're talking the spirit, so it's,
yes.
so your spirit is racist and biased and prejudicial, is it not?
It's not his spirit.
No, but the spirit of the office. I'm just trying to find, because we were indicated, as Justice McCaffrey said, we've indicated that all the different counties have different procedures. I just want to see where the spirit is in particularly large counties where, unfortunately, some members of our population get stopped and arrested a lot more than others.
I hope the justice is not inferring that our office is racist.
No, not at all. I'm talking about, we're talking spirit and its application throughout the 60 judicial districts.
Ultimately, if there's no charges filed, if the prosecutor has an opportunity to look into these arrests and sees that they shouldn't have been arrested, or blood came back negative for any alcohol or whatnot, or drugs, then I've signed off on, without exaggeration, thousands of these in my career, many thousands. I look and see if there's a pending charge, take a look at it. If I know about a DUI arrest, I will look into that. I will look to see if there's blood. If there's no blood, I'll watch the MVR. You can usually tell if somebody's drunk or high based upon the MVR. That's all I'm asking for here would be the opportunity.
You're asking for stuff that's not inscribed in the statute.
And I understand that.
Okay.
Yes.
Fair enough. Thank you. You're doing a good job.
Since you've come here from Gettysburg, I should say that your effort sort of reminds me of Pickett's charge.
Which is no reflection on your abilities.
No,
sir.
you're doing a fantastic job.
credit, really.
Yeah, really.
Or
Anything
Pickett's
you'd
charge
like
for
to-
that matter.
Anything you'd like to say before you sit down?
I think I've said enough.
You did a great job.
You did the best you could with it. Thank you.
We look forward to you coming back.
Mr. Mitter, would you call the next case?
Let's see if I back.
ESP NE LLC versus Bureau of Labor and Law Compliance. Representing the Bureau, Mr. Justin Romano. Representing PSP NE, Mr. Anthony Hass.
Okay, we're at the end of the line here, so you can feel free to take whatever time you'd like. In this appeal by allowance, we are asked to address whether public funds were used for the construction of a new headquarters for the Pennsylvania State Police in Wyoming County, such that the project developer was obligated to pay contractors prevailing wages under the Pennsylvania Prevailing Wage Act. Specifically, we consider whether a lease which mandated the state police pay the developer a fixed monthly lease payment for 20 years, payments which included the amortized value of the construction costs, is a bona fide lease under our precedent, or whether the lease actually is a means of indirectly financing the construction costs. In making this assessment, we also consider the degree of financial risk a developer must assume under a lease with a government entity for non-payment in order to establish it is a bona fide lease. Please proceed.
Good afternoon, Justices, and may it please the Court. Justin Romano on behalf of the Department of Labor and Industry, Bureau of Labor Law Compliance. Before we begin, one point of clarification. The developer in this case is named PSP NE LLC. That is not a reference to the Pennsylvania State Police. So throughout the argument, I'll refer to the Aplt here as the developer, and I'll refer to the state police as the state police, because you may have some questions about the interplay there.
Okay, I want to make sure I understand what you just said. PSPNE is not state police.
That is not the state police. That is a private developer. That's correct.
Before you launch into your argument, can I get a point of clarification?
Yes.
Is there any finding or record evidence that prevailing wage was not paid in the construction of this building?
There's not.
So why are we here? Because if prevailing wage there's no evidence that there was a violation, let's assume it applied that there was a violation, why did this, what are we fighting over?
It's a fair question, and the inception of this case was the Bureau of Labor Law Compliance sending a letter to the developer in this case and notifying them that it was their position that prevailing wage applied to this construction project. In response to that, the developer filed a grievance under the Prevailing Wage Appeal Board regulations and said, that's incorrect, we want to litigate that. It went before the Prevailing Wage Appeal Board, Commonwealth Court, and here we are today.
So, okay, so when they raised this point that there's no they're the ones that started this party.
They took the position that this construction project was not a prevailing wage covered project.
So isn't this effectively an advisory opinion?
It wouldn't be, because it's conceivable that if this court finds that this is a covered project, an audit could take place. The Bureau of Labor Law Compliance could request records, assess those, compare those to the relevant prevailing wage rates, and determine
assess
that there's
a penalty of some sort or something.
Correct.
Okay, thank you.
To address the lens through which we should consider this issue, we only have to go back as far as the Ursinus case fall of last year, which says very clearly that when you're dealing with a prevailing wage coverage question, you have to look at the economic reality of the specific transaction at issue. That's the...
I'll just ask you a very simple question. I'm going to ask your opponent the same exact question. But for the commitment of taxpayer monies, does this project get built?
I don't know that I can answer that question, Your Honor.
No?
It's certainly not in the record.
Didn't a lender require a lease with specific financial terms to make sure that it was repaid?
It did.
I'll ask you the question again. But for the commission of taxpayer monies through this particular lease, does this project get built?
I can't speak to the fact that the lender required public financing through a state police lease to secure their loan for this construction. I think it's reasonable to ascertain, based upon how this transaction was arranged, that some security, in this case, public financing over time, was required to get that initial loan to break ground on this project.
So you're telling, the answer to the question is yes?
I think it's likely yes.
The project does not get built but for the commitment of Commonwealth taxpayer monies to this project?
Our position is yes, if you look at the economic realities of this transaction.
Then to follow up to I think that's a good question to ask. And my follow-up question would be, is it your position that the mere contingency or the fact of that some portion of the construction costs are from public funding, does that standing alone, as a matter of law, is that standing alone enough to trigger the PWA?
Well, Your Honor, you have to look at the elements under the definition of public work under the Prevailing Wage Act. Certain work, construction, demolition, reconstruction, and so forth, under contract, exceeding $25,000 with public funds. Our position is if you look at the economic realities of this transaction, all four of those elements are met. This is a covered project.
Well,
pretty straightforward.
All four of those elements were arguably met in Hance as well. And this court distinguished, maybe rightly or wrongly, based on the statutory language, but sort of true leases where there's always a portion of your rent payment that covers, the cost of constructing the building or maintaining the building. So that's really why we're here, right? That's why this bona fide lease language is coming into play. That's why these design build concepts are just coming into play. We have carved out true leases from the Prevailing Wage Act. And the question is, if we're going to keep Hance, what is not a true lease?
Your Honor, our position is that the Commonwealth Court mistakenly relied on Hance in this particular case with these particular facts. Hance deals with a traditional landlord-tenant lease agreement.
We're not looking to disturb that.
We're not looking to disturb that. Our position is you don't even need to go there because this is a build-to-suit arrangement. There's a construction component that's expressly incorporated into the lease. It's highly detailed. It's 128 pages. It talks about gun ranges, evidence lockers, polygraph room, highly specific to this particular use. And there may be a lease term, but there's also a construction component to this. And this takes us out of the Lance framework. So you don't even need to get to Hance to do the analysis. You need to look at the economic realities as set forth by Ursinus last year. Look at the record here, including the transaction documents, which incorporate the construction specifications. And in Article 3, Section 16 say, we're constructing this in exchange for the rent. It's in the record. If you look at that, it's dispositive. This is a covered project.
Counsel, I have maybe a question that's far too basic, but according to this lease, paragraph 32, it says payment of prevailing minimum wages, where the lessor and lessor's contractors must comply with following conditions, et cetera, that being payment of prevailing minimum wages. Why aren't we just talking about that?
It's a fair question, Your Honor.
I mean, it just seems there's an agreement that we're being asked to look at. Why doesn't that just control it?
I don't think there's any dispute in this case that the developer agreed to pay prevailing wages in their contract. The reason we're not here on a breach of contract case is because L&I enforces the Prevailing Wage Act. And to Justice Brobson's question, we got here through a grievance process. So the
Well, we are looking at I'm not looking at this in terms of enforcing the contract. I'm looking at it in terms of how the parties viewed this particular project.
at the very least, that puts the developer on notice that prevailing wage applies.
Well, it doesn't put them on notice, it
it
actually commits them to it.
Well, that creates a contractual claim.
Correct.
We're here
Well, it
based on
commits them-
statutory
It
enforcement.
committed them to prevailing wage. It didn't say, we agree that this project is governed by the Prevailing Wage Act.
Arguably, but again, Your Honor, we're not here to proceed under those contractual rights.
Right, I still think it's weird that it came, I still think that, I understand why we're here now, thank you for your answer to my question, but again, for all we know, prevailing wage was paid on this project.
It's an unusual administrative process that got us here. We concede that. However, until there's an audit, we don't know.
Or until L&I has, for some reason, maybe they have, maybe they haven't, chosen not to do something here.
Well, what could have happened in the first instance is rather than the developer taking the position that we're not covered, they could have said, here's what we're paying our workers, here's our payroll, and if it's in compliance, we're not here today. That didn't happen.
Counsel, recognizing the distinctions between this case and Hans, like for example, in Hans, the building was being built without any commitment of any public entity moving into it. So that was a building that was constructed essentially on speculation. So that takes it out of the context that we're dealing with. But how do you address the Commonwealth Court's analysis of the allocation of risk falling on the contractor here?
Well, I agree with Your Honor that this is fundamentally different than Hans, which is a shell construction. This is a highly specific building. Risk allocation goes to the economic realities of the transaction. All roads lead back to economic realities in light of Ursinus. When you're outside of Hans.
Why was the Commonwealth Court wrong on their assessment of the realities, the economic realities?
Well, the Commonwealth applied Hans exclusively. And under the Hans framework, under the Hans analysis, you don't get to economic realities until you meet those initial prongs, the bona fide lease, and then the burden shifts. And you have to prove the economic realities are, that actually isn't a bona fide lease. That's a disguised construction contract. We don't need to get there because this is a build-to-suit arrangement, which, by the way, was specifically contemplated by Hans, in dicta, admittedly. But the Hans court was very clear in saying, well, this isn't a build-to-suit arrangement. We want to be entirely clear about that. Well, this is the build-to-suit arrangement that brings us before the court today.
You're not answering I'm not sure, respectfully, I don't think you asked, Justice Donahue is asking you specifically, what is the risk allocation to the Commonwealth that tilts in favor of this being a project subject to the Act?
That's right. Our position is that with the underlying record in this case, the Commonwealth does bear substantial risk. If there's a termination for convenience, for instance, which is only permitted after 10 years, $1.5 million in unamortized costs need to be paid, plus a 3-month penalty. That's $2 million. If you're talking about risk allocation, there's virtually no conceivable scenario where there's not public money flowing to this specific project.
Yeah, but other than that, which I think is interesting, the only risk in the event the builder somehow defaults to the bank is the Commonwealth will continue to pay what it's contractually obligated to pay as a tenant.
That's correct.
Yeah, there's no heightened risk of, well, now the lien is all due and the Commonwealth's not going to pay the loan off.
That's correct.
Yeah.
But it's important to consider.
That's what I think the Commonwealth Court was saying, is that the risk here isn't any different than, a justice who has space leased in a private building to do a build out, and that there's some amortized cost associated with the build out, in the lease terms.
But it's important to consider the language of the Prevailing Wage Act, which has a $25,000 threshold, but doesn't specify the minimum amount of public dollars that need to flow to trigger coverage. So if $1 of public funds goes to a publicly funded construction project that exceeds $25,000 in its construction and it's under contract.
But that would make Hance bad law. That argument would make Hance bad law, because in Hance specifically, there was a finding that part of the lease went to pay for cost of construction.
Well, Hance is a different case altogether, because the only reason that prevailing wage coverage was triggered there was under the charter school law. So there wasn't actually public funding there. And there was a demarcation in Hance which said the construction of the shell in the first instance is not covered. It's not covered. Only Section 2, which is the fit out, which the charter school is responsible for, is covered, and it's only covered not because it's publicly financed, but because the charter school law says charter schools are constructed under prevailing wage.
The reason why I'm asking these questions is, you said that if $1 of public money goes toward the construction, the law is triggered.
Assuming
in every commercial lease, there is usually a cost recovery component in the rent. That would be, Hance basically acknowledged a true lease, that true leases did not really apply, unless you could prove evidence that that the cost recovery exceeded the normal business cost recovery cycle. You agree?
Yes.
Okay. Your argument, as I understand what you're saying, is no, Hance is wrong, because if $1 of public money in a lease situation goes toward paying the construction, that triggers a statute.
We're not saying that Hance is wrong. We're saying Hance doesn't apply because this is a build-to-suit arrangement, which is fundamentally different.
So, but I completely understand the build-to-suit distinction. I'm trying to understand your actual broader legal position. Is it your position that every true lease that has a cost recovery component built into the rent and is paid for by public dollars triggers the Prevailing Wage Act?
It is not our position.
Okay.
Say that again, because I'm really troubled, might be a strong word, but I question the notion that the recovery of the amortization costs should be considered as part of the lease payments. I mean, it's a different concept. It kicks in here when there's a default. And so what's being recovered there through public funds in this context are actual costs of construction. Correct?
I'm not sure I understand your question, Your Honor.
Unamortized cost of construction.
That's correct.
Are being paid by the Commonwealth in the event of a default.
In the event of a termination for convenience after 10 years, that's correct.
And is year 11 in that hypothetical, or that scenario rather, is it the same, say, year 11 as year 15? Any different?
Yes.
It is different.
I believe, no, I believe it's the same scenario. Yeah.
But
The termination for convenience kicks in after 10 years. So at any point after that 10 year, the Commonwealth, if they decide to walk away from this facility, then they're on the hook for those unamortized costs, plus the 3-month penalty.
That's because they're unamortized. The amortized cost of constructions are built into the monthly, or into the rent.
Yes, that's correct.
Right.
But this is not the amortized costs, correct? In the event of a termination for convenience after 10 years, what is the Commonwealth on the hook for?
The unamortized costs, which are specified, they're in the lease agreement, it's $1.5 million.
Amortized costs are built into the lease payments. This would suggest that the unamortized costs are different, and I would look at them differently. I would look at that as a payment by the Commonwealth of the cost of construction.
So I think we can put some numbers to this and it might make a little more sense. So if 10 years in one day, the state police say, we're walking away from this, we find alternative space that's a better deal. What are they in for at that point in time? So it's $153,000 per month over the course of 10 years. That's roughly $18.5 million in rent. The penalties that kick in at that point in time are the $1.5 million in unamortized cost plus a 3-time monthly penalty. So it's an additional $2 million. So at that point in time, if the state police say, we're done with this, we're moving on, $20.5 million. That's the public funding that goes at that point in time.
Taxpayer money.
That's correct.
And what was the amount of the loan to construct? 15 million?
17.5.
So what's the risk?
So from our perspective, there's virtually no risk that there's not going to be public money going to this job. And that's an important question, Your Honor, because again, we're talking about a single public dollar. So the Commonwealth Court got confused on this, and what they said is, well, the developer might lose their shirt on this. They might lose $10 million under, this particular scenario. Well, that's not the relevant question from a prevailing wage standpoint. The prevailing wage standpoint is public money going to this? And if the developer loses $10 million, but the Commonwealth's in for $5 million, assuming the other elements of public work are met, that's a covered project.
But you then went back to the single dollar thing. And I know Stani asked you about at every early lease termination where there's been a construction build out, if you terminate the lease early, there's usually a clause that requires you to reimburse some form of unamortized cost because you're not paying them amortized as part of your rent payments. That provision is in event of a default, so we have to hypothesize an early termination. But your point is because the amortized costs are included in the rent payments, they're paying for construction costs from day one. And that's what makes it a Prevailing Wage Act violation.
Our point is that the build-to-suit component of this is what makes it different than a traditional landlord-tenant arrangement.
I completely agree with you on that. I'm trying to respond to this idea that this lease is somehow, other than the build-to-suit aspect.
Well, that's the fundamental difference here.
Okay, but we're asking these questions about this amortized and unamortized portion. The fact of the matter is there is a component, the Commonwealth is paying. I don't think there's any dispute that part of the monthly lease payments are going toward the cost of construction on an amortized basis. There doesn't seem to be any dispute on that.
Correct.
Right?
I'm not sure the developer would agree with that.
Well, okay, let's assume that's true. Why does it matter that if there's a default at the end of 10 years, there's going to be some sort of unamortized kicker?
Because there was a question about risk, and that's an element of the Commonwealth's risk here. In addition to the monthly payments, their contractual obligations.
But that's a risk on the basis of the Commonwealth walking away.
That's correct. But the question was generally about risk allocation, and why is that important? Well, that's a consideration here when it comes to assessing that.
I don't disagree with you, risk is a consideration, but doesn't the risk have to be concrete from the point of the exercise of the contract, not a contingent risk?
I'm not sure that there's any precedent that requires it to be concrete in those terms. I think we look at the economic realities of the transaction. What is the likelihood of risk?
Why are we looking at risk? I mean, I know you're not questioning hands, but the whole analysis of risk allocation came from tax law. How is that applicable to the situation that we're talking about here?
Our position is it's not necessarily even relevant for us to be successful on our claim. You don't even need to get there. If you look at the underlying record here, you look at the language of the Prevailing Wage Act, and you look at the economic realities tests set forth in Ursinus.
I'm more or less questioning hands. You don't have to do that. And we
Right.
don't necessarily have to get there. But the Prevailing Wage Act is very specific in what you look at, which is are tax dollars going to the project?
That's correct.
The whole complication of the risk analysis that takes place is something that just confuses me.
I agree with you, and I don't think we need to get there for the Bureau of Labor Law Compliance to be successful with its position. If you look at the underlying record here and you look at the Prevailing Wage Act, this is a publicly funded construction project, $17 million to build, expressly conditional on 128 pages of specifications, expressly conditioned on 128 pages of specifications. That is apples and oranges when you're talking about Hans, which is leasing a shell building, which could have been used for other purposes. That's why you don't need to get to Hans. If you get to Hans, we still win, and we address that at length in our brief, but you don't need to get to Hans. All you need to do is look at the record, the statute, and consider the economic realities of this transaction, including what happened on the front end and the construction of this project.
Mr. Romano, you've given us an excellent argument. Is there anything else you feel compelled to say?
The only thing I would add here is the outcome here is that the Pennsylvania State Police get a brand new building that meets their needs. The developer's in a position to make millions of dollars, but the construction workers who worked on the project may not get paid what they're owed under Pennsylvania law. Thank you.
All right, thank you. Let's hear from opposing counsel, Mr. Hasse.
Madam Chief Justice, and may it please the court. My name is Anthony Hasse. I'm at the law firm of Spillman, Thomas & Battle, here today on behalf of the Aplt, PSP, NE, LLC. As Mr. Romano clarified, I as well will be referring to them as developer throughout this argument. Developer respectfully requests that this honorable court affirm the Commonwealth Court's decision that the Prevailing Wage Act does not apply to the construction of the state police facility located in Luzerne County, Pennsylvania, because no public funds were used in the construction of the facility, because under the Hands test, the developer made a prima facie case that its lease was a bona fide lease, showing that the funding of the construction of the facility to be rented by the state police did not come from a public body, because the parties stipulated that the developer is solely obligated to repay the construction loan that was taken out and is solely the party to incur the risks associated with committing to such a loan agreement, and for the other reasons stated in Hands. As this honorable court knows, Penn National One was one of the first cases that dealt with determining whether or not a construction project was a public work that would be subject to the Prevailing Wage Act. It laid out the 4 elements that we're dealing with here, but most specifically the paid for in whole or in part aspect of the case. In 500 James Hands Court, obviously this court is aware that there was a burden shifting test that was handed down in order to determine whether or not the act applies. Now, Hands should control this matter. While Hands was dealing with a pre-development lease and the matter at hand is a built-to-suit construction contract, they're a difference without a distinction. In both scenarios, you have a party looking to lease space that will be sufficient for their operational requirements, and they seek a space to go and use that will fulfill those operational requirements. While in Hands we were dealing with the charter school, in this matter we're dealing with the state police facility. Now, obviously the state police have more needs than some tenants. However, it doesn't take away from the fact that the developer was able to provide them with a space that fit their operational requirements. Under Hands, agreement is able to establish a prima facie case that the Prevailing Wage Act does not apply, where they're able to show that they bear the risk of the mortgagor obligations in a construction, where no public financing was used in the construction of the facility, and where the relationship between the covered entity is as a lessor and lessee. Here, developer was able to meet all of those standards at the grievance level. At that point, the burden was to shift to the Bureau to say that the economic reality of this is not so, and because the economic reality does not apply, or is not as it seems on paper, the Prevailing Wage Act should apply. In this case, appellant's position that the funds that are being paid in the form of rent ignores the reality that the state police receive value in being able to use and occupy somebody else's property. Now,
Yeah, but that's not the test. The test is whether public monies are basically being used. I mean, I guess I warned you, so you had a lot of time to think about it, so I'm going to ask you the question I promised to ask you, which is pretty much a yes or no answer in my mind. But for the commitment of Commonwealth dollars through this lease, does this project get built?
no, but that doesn't matter in our analysis here, because as this honorable court determined in Hands, adding a but-for element to the interpretation of the Prevailing Wage Act would be to add extra substance to the act that's not within the language of the act as it's written.
Yeah, but in this particular case, what we're talking about is a lender that is making as a requirement a particular lease. And the lease requirement is to make sure that the debt service on the debt is actually being paid, and that money's coming from one source, which is the Pennsylvania State Police lease, correct?
Right, and that's a matter of collateral. It's under the commercial lease, and that's
That's my question. This is a specifically built for project that is only built because the bank is willing to loan the developer the money, and he's only willing to loan the developer money under strict specific terms and conditions, which require a stream of revenue to pay back the bank. So that's why I asked the question about risk allocation. And by the way, I'm not a proponent of the risk allocation standard. I don't think risk allocation really has anything to do with this particular case. It kind of came out of the tax analysis in the Hands case. My question in this particular case is, your client didn't take any risk, and all of the monies to pay for this particular project is coming from tax dollars.
So, respectfully, I disagree that my client didn't take on any risk in this case. Again, they took out a $17 million note that was guaranteed by the developer and two guarantors who are parties to the developer. Now, that $17 million, I understand that you don't appreciate the risk analysis that was given in Hance. However, as the controlling case, Hance laid out several factors in identifying risk that a party can bear. And merely because developer has a what I would call a grade A tenant in the state doesn't mean that it still hasn't taken out this financial burden.
What's the burden?
The burden is if something happens during the life of the lease, that they're on the hook for.
Like what?
Well, for example,
Pennsylvania decides to cede from the union, we go bankrupt?
well, if there's a budget impasse, for example, Your Honor, then the funds that would normally go toward rent are withheld for however long it takes to move past the budget impasse. During that time, the state police nor the Commonwealth are on the hook for these loan repayments that were taken out to finance the construction project. That's up to the developer to do, and there might be cases where they need to take out additional lines of credit to service the initial loan, which is another layer of risk that they bear in this matter.
I think the risk analysis came from the Penn National line of cases, not from Hance. The risk being one of the four factors you look at.
Yeah, correct, and it
came out
was
of Penn
expanded
National.
upon in Hance.
But the risk that your client has is, I think that's the point, is your client has the risk of, if the Commonwealth defaults, which is not unheard of, it's entirely possible, you will still be on the hook to the bank.
Correct. And
for the loan. That's your point.
Yes.
And the Commonwealth risk, to the extent the Commonwealth has any in the event of your default, is status quo, because they'll just continue to pay the rent.
Indeed.
Okay.
And even if at some point during the future, developer is, say, hypothetically purchased by another entity, and in that purchase agreement, the developer or the purchasing party pays off the entirety of the loan. So at year whatever down the line, the entirety of the loan is paid off. The state police still are obligated to pay rent for the use and occupancy of the facility.
There's nothing in the lease that says if this loan is paid off, your rent is going down.
Correct. No, nothing. And in fact, there's no obligation under the loan agreement itself which attributes any risk to the Commonwealth, but for the fact that it needs to continue to pay the rent. With that, it seems that there's no further questions. I will wrap up by asking this honorable court to look at, no, before I do that, I apologize. So, classic one more question, right? The financing structure in this case is such that the Commonwealth and the state police are paying rent for use and occupancy of a 55,000 square foot facility that sits on 20 acres. There's nothing in the record that indicates that that rent is exorbitant or out of the ordinary for what the Commonwealth is receiving. Additionally, the developer in this matter did take out a private bank loan. The financial origins in this case are through the private bank loan. Unlike other cases that this court has heard, like 22 South 40th Street, where you have a grant in play, or the TIF financing in Penn National 2, or the charter school regulation in Mosaica and in the Hance case. This is the most straightforward public or lack of public funding that the court could see. The language of the prevailing wage law is clear, and it requires that public funds be used to finance a construction project. The facts of this...
In whole or in part?
Either.
Right.
In whole or in part. And it's developer's position that none were used. The facts of this case, the stipulation, the parties agree that the developer was the party who paid for and took the risk on the funding. For that reason, we ask this honorable court to affirm the Commonwealth Court decision that the Prevailing Wage Act did not apply to the state police facility in Luzerne County, Pennsylvania.
Thank you, Mr. Hassey.
Thank you.
Another excellent argument, and this is a very close case. We will take it under advisement. Mr. Minner, seeing no further cases for today, would you adjourn the court?
Court is adjourned.
Nice work, counsel. Thank you.
Thank you, Your Honor.